sometimes like all you want to do is run. Hear me out, hear me out. If all the things you never show, there are the things I want to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know. Losing almost all my energy. It's getting hard to talk to you, and I'm the only one who speaks. It's all the things you never show. There are the things I want to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know.
Okay, 1 second here. Okay, I was so strange because I couldn't see the viewers, and I'm like, what's going on? Anyways, first of all, happy Halloween. Good morning, Gen Z. Good morning. And again, thank you, Jen. I believe it was you that sent the PayPal the other day. And I totally was forgetting to set up the thing. My computer was bugging out on me just as I was about to go live. And I was like panicking, and I was like, what's wrong with you, Chrome? Hi, boy, mom. Good morning. Good morning. Okay, so of course, the court date is today. I was just going to kind of come chill, say happy Halloween. And just as I actually was getting the live ready, a few documents had come out. So that's what we're going to look at in just a moment. Yeah, coffee time. You know what? Just bear with me for a moment here as I just finished setting up the stream. Sometimes I forget to do that if I'm in a rush, but it was because of the Google issue that I was like, So anyways, just give me a sec. Bear with me here. Just want to make sure everything's set up here. So of course, this is Libby's favorite holiday. Okay, there. Copy. Okay. I just was asking Adam if I was live or not, just because it was freaking me out. I was like, wait, what? What's going on? So let me just pull in a picture here for a second. I'll show it to you guys. So Adam had just sent me a picture, so I'm just going to quickly show it to you guys here. Okay, come on now. Work with me, StreamYard. Share screen. Window. Good morning. Oh, yeah, it's like 6 o'clock. Okay, so there's Richard Allen, obviously making his way into the courtroom. Just give me one more second here so I can finish it off. Give me a sec, guys, for 1 second. Do my last thing. Don't forget to give it a like if you guys could. And we'll get into those documents in just a second. Just going to do up my pinned comment. Okay, I think I'm good to go now. All right. Good morning. So again, happy Halloween to everyone, whatever time it is for you, whether it's morning, afternoon, or in the evening time in the UK. So again, this is Richard Allen, and again, there's no cameras in the court and stuff like that. So, updates are going to have to come as they kind of come out at the end of the day. So let me stop screen there, and then we're going to go back to share screen. And we're going to go over. Okay, so there was 4 documents that had come in this morning. Let me just make these a little bit bigger for you. Maybe that's just a little tad too big. We'll do it about 192. Let me see if that's good for you guys. Yeah, well, I'm on a computer. Some of you guys are on phones and that, and you have to. It's hard to see this stuff. But anyway, so let's see which document this one is. Okay, so defendant Richard Allen. Oh, let's go to the top. Appearance form. Richard Allen, case type of proceeding. Prosecuting attorney. Now, I'm sorry, but who's James Luttrell? I have no idea who that name is. Will the state accept service by fax? Yes. Arrest report number, transaction control number not available, state ID not available, additional information required by state or local rules. The undersigned certificate that a copy of the foregoing instrument was served upon. The undersigned certifies that a copy of the foregoing instrument was served upon attorney Robert Cliff Scremin and William Satino Librado on this day of October 30th, obviously, of 2023 through the e-filing system. Huh. I wonder, well, let me just, he is a new member of the prosecution team. He's McLean. Oh, is that who that is? Oh. Okay. Well then. So let's see what else. Okay, so there's that one. And let me go to my files. Then there's the appearance one. So I'll just go over this again because we did this yesterday, and I want to make be very thankful that if you haven't seen yesterday's live, we had on, of course, Travis Williamson, attorney and a law attorney that's been practicing in Austin, Texas, for just over 35 years. So today happened after, yeah, cold truth. I mean, because of your question there, he believed it was going to happen today. And I was listening to the prosecutor's podcast and same thing, it's just a matter of what was going to happen. Because so I don't know what time you left the chat, but it was like that was a question asked multiple times. It was like, so is tomorrow happening? That's all we and so right, it made sense once he explained, because I can't remember, because I think when we asked that question, when I put your question up, I think it got sidetracked a little in there, and I don't remember ever coming to like the kind of conclusion of it. That's why I re-asked it a couple times more, because what's going to happen today is a whole different story. That was sitting next to, oh, okay, is that who that is? I actually never heard his name before up until today. So yesterday, Baldwin, of course, we saw this yesterday but it hadn't been filed yet. But then later on, we had heard that it was filed. So Attorney Baldwin enters his appearance as Mr. Allen's privately contracted lawyer. Attorney Baldwin acknowledges his prior representation of Mr. Allen as his contracted public defender and reaffirms that he, Attorney Baldwin, did not and has not voluntarily withdrawn from Mr. Allen's case in said capacity. The filing of this appearance is intended to convert Attorney Baldwin's status as Mr. Allen's public defender to Mr. Allen's private counsel, wherein Attorney Baldwin will move forward with said representation on a pro bono basis in the event that he is not reinstated as Mr. Allen's public defender. With well over 1,000 hours of time spent reviewing evidence and analyzing evidence and preparing Mr. Allen's case for trial, and with the desire to have the court hear suppression order or evidence and the desire to get the case in front of the jury as soon as possible in order to honor Mr. Allen's 4th, 5th, 6th Amendment rights, Attorney Baldwin enters his appearance. Will defendant accept the facts and serve? Yes, respectfully. Okay, so then there's that filing. Then we'll go to this one. Get a little bit, it's too big. Come on, Mr. PDF. I like how you touch it and it instantly jumps up. Okay, so let's see this one. Okay, state of Indiana, county of Carroll, state of Indiana. E-filing appearance by attorney in criminal case. This appearance form must be filed on behalf of every party in the criminal case. The party on whose behalf this form is being filed, defendant, attorney information for services required, trial. Okay, so name Librato, and obviously that's the public defender, one of the two. Each attorney specified on this appearance certifies that the contact information listed for him or her, whatever, the Indiana Supreme Court rule of attorneys is current and accurate, and the appearance acknowledges that all orders, opinions, and notices from the court in this matter that are served under Trial Rule 86 will be sent to the attorney at the email addresses specified by attorney on the roll of attorneys, regardless of the contact information listed above for the attorney. Okay, let's see. Let's see what these questions are. Attorney can review and update. So this is MR case type is defined in Administrative Rule 8. Okay. This case involves child support issues. No. Okay, so just simply, so that's simply a form. Okay. So basically just putting in their, I guess, X's where they belong exactly. Stuff like that. So that one's okay, boring. And then the last one would be must be Rosie. Let's see here. I'm sorry, you guys, I can't see the chat right now. Not while I'm on this screen here. Okay, so pro bono, Richard Allen, address of pro se. Bradley Rosie. Attorney Rosie enters his appearance as Mr. Allen's privately contacted lawyer. I'm just trying to see if it says the same thing. Okay, I mean, his is basically the same thing, right? The filing of his appearance is intended to convert Attorney Rosie's status as Mr. Allen's public defender to Mr. Allen's private counsel, wherein Attorney Rosie will forward with said representation on a pro bono basis in the event that Attorney Rosie is not reinstated. So pretty much almost the same wording with hundreds of hours. It doesn't say 1,000 hours. It says with hundreds of hours. Time spent reviewing evidence, taking depositions, communicating with potential witnesses, and preparing Mr. Allen's case for trial with the desire to have the court hear suppression evidence and the desire to get this case in front of a jury. Okay, so same thing on there. I keep getting calls. So okay. Wow, my coffee I made, I totally forgot I even made it. That is the question for every hearing on there. I mean, happy Halloween, Tommen. And so again, if you guys haven't hit that like button, if you guys could do that, that would be great. So as things kind of maybe roll out and, people message me and stuff like that, hopefully we can get some sort of sense of what's happening in that courtroom there today. I don't know. How long, Mel, how long do you think it's gonna take? How long do you think court's gonna take? I think there was a video. Which is the one? I think it was this one. Let's just see what this one says. Stop screen media. Let's just listen to this one. I think it was from yesterday, I believe. Let's just see what this one has to say.
What can we do in the face of climate uncertainty?
Not sure.
We can come together. We can fight back with cleaner water and help.
Okay, thank you.
It has been nearly 7 years now since the Delphi murders took place. And now this case is heading to the Indiana Supreme Court before a jury has even had a chance to weigh in on the case.
The man accused of killing Abby Williams and Libby German is Richard Allen, but the latest court battle is actually between his original lawyers and the special judge in this case.
And now Indiana Supreme Court is being asked to step in. So new documents filed just today asked the Supreme Court to block certain moves by the judge in this case. And all of this as we expect this hearing for the trial tomorrow morning.
This level of legal fighting is rare in Indiana. So our senior investigative reporter, Bob Siegel, was the first to break this story on 13 News at noon. Bob, what does it mean for the case?
Well, the petition that was just filed with the Indiana Supreme Court is a direct result of the bizarre developments that have happened in the Delphi case over the last few weeks. Last week, the judge appointed 2 new attorneys to take over as Richard Allen's public defenders because she said his original attorney stepped down. Then the original lawyer said they were forced to withdraw against their will, and they filed motions to stay on the case and asked the judge to step down. The judge responded by ordering those new motions to be stricken from the official court records. Monday morning, this petition was filed with the Supreme Court by an entirely different group of attorneys representing Richard Allen. They want the Supreme Court to rule the judge acted inappropriately by removing court records from the file, and they want all the recent court filings reinstated.
So it's really a fancy legal way of saying follow the rules and don't break them again.
Katie Jackson Lindsay is a longtime defense attorney and a former prosecutor. She says today's request filed with the Supreme Court is really to hold the judge accountable for ensuring that important court records are public like the Supreme Court intended.
Those attorneys are not only raising a violation of Richard Allen's rights, they're raising a violation of the rights of the public, because we all have a right to know, to full transparency of our court system. And so to that end, she has not complied with the rules.
The latest court filing includes details about the Delphi legal case we've never seen before, including a recent letter from Richard Allen stating that he wants his original attorneys to continue to represent him. There's also a series of emails between the defense attorneys, the prosecutor, and the judge detailing a recent leak of crime scene photos and how a person believed responsible for the leak just died by suicide. In her response, the judge wrote, "I'm deeply concerned that Mr. Allen's defense is being compromised by all these recent events." Then she ordered the original defense team to stop working on the case. Right now, the defense for Richard Allen, is this just a complete mess and total chaos?
Yes, it is a complete mess and total chaos. And I think because of the attention that this case has received, we're sometimes losing sight of the life and death at the foundation of it, right? You have 2 young girls who lost their lives and their families are hanging in the balance, really wanting justice. You have a man who's been accused of this crime, the most serious crime on our books, who's wanting his day in court. And at every turn, something unusual is happening, something extraordinary is happening. And what we know above all else is that this that is happening now is more than likely going to cause a delay in the proceedings.
The Supreme Court is taking this under advisement, has not yet decided whether it will act on the request filed today. Richard Allen is scheduled to be back in court tomorrow morning, and of course, 13 News will be there.
I know you have the early wake-up call, and you'll cover it for us. All right, Bob, thank you.
You're welcome.
Remember, you can track the Delphi murders case from the very beginning to this latest flurry of legal fighting. It's all at WTHR.com.
Close that one off, and then we'll bring up Jen's one that she sent me. Is this the right one? Right here. Thanks, Jen. Delphi trains. Hey, kiddos. Okay. That's I'll just play that again for people that are just coming in. I don't think we need to listen to the sound effects though. I think that was it. Yeah. Okay. So again, there was some court filings for the ones that we basically were looking at last night, but we didn't have Rosie's one. You know, for the pro bono. Basically, if they're not reinstated, um, you know, basically they're gonna be as lawyers pro bono. So we'll see how today's comes from, as well as so basically there was just 4 filings. One wasn't, doesn't really matter. It was just you know, like a application type form by Librado, just for the information and stuff like that. Other than that, it was attorney Rosie and Baldwin that I showed you guys. Morning, Charmaine. Yeah, Charmaine, you know, if you're bored, Charmaine, you can come on here and let me know if you want to join me up here. I'm just kind of chilling by myself, wishing everyone a happy Halloween. Well, I guess I should. You guys can stare at me because, ooh, happy Halloween. And then hopefully tonight, like I said, we'll do the Halloween live here as well. But yeah, Charmaine, let me know in chatter if you do want to join me, because I'm just chilling by myself, really. Adam doesn't love me. I don't think Deb loves me. I feel like Travis doesn't love me right now. I feel like nobody does. No, I'm confused. Who the heck is Ari's Lars? Well, I mean, at the end of the day, that's what I don't know if we're gonna find out today exactly what's going on, right? So I think all of us are a bit confused with what's truly going on with you know, this whole thing this morning, exactly what's happening. But obviously Baldwin and Rosie, sorry. It's really hard not to say Rosie. I keep wanting to say Rosie, not Rosie on there. But yeah. So I don't think any of us are really certain what's going on, besides the people that are in court. Let me just see if there's anything else I can play for you guys here. We already played that one. Let's see here. Richard arrives. Oh, let's play this one. Thank you, Butterfly. Okay, let's play this one a couple minutes long.
Another step in the Delphi murders case.
Richard Allen, the man charged in the deaths of Abby Williams and Libby German, will be back in court in Carroll County. Samantha Johnson is live there this morning. Sam, a lot of new information over the past few days. What can we expect there today?
Well, Julia, we are expecting a big crowd here today. In fact, you can see there's already a few folks lined up here at the door. We just saw police come through with their canine crews to do a security sweep. This will be the first time we've seen Richard Allen in more than 4 months. We do expect him to be here in person for today's hearing. The bigger question, and perhaps the main focus today, though, might be who is going to be representing him. And that's because you'll remember it was just a few days ago that the judge in this case, Judge Frances Gull, appointed 2 new attorneys for Allen after she said Allen's original public defenders stepped down. Well, that's when the original attorneys fought back, saying they were coerced into withdrawing from this case. And now they're fighting to stay on it. In fact, 13 News has confirmed the original defense team has filed paperwork to continue representing Allen pro bono if need be. Now, another twist in this case this morning. In just the last 24 hours, a different group of attorneys has filed a petition with the Indiana Supreme Court. They want the justices to rule that Judge Gull acted inappropriately, by removing court records from Allen's file. So we took those concerns to a longtime defense attorney and former prosecutor who is not associated with this case. We asked her what a petition like this could really mean. Take a listen.
To that end, essentially, they're saying, can you tell the lower court to stop breaking the rules? So it's really a fancy legal way of saying, follow the rules and don't break them again.
So what could this mean really for the timing of this case, right? We've got that information for you right now at WTHR.com. Today's hearing is still scheduled for 9 o'clock. Despite all these new developments, we, of course, plan to be inside. And we know we've talked a lot about Richard Allen's legal team. What about Richard Allen? We will take a closer look at that coming up this morning at 6:30.
We'll see you then. Thank you, Samantha.
Oh, I was talking to myself, huh? Yeah, there's no sound on the video because all you're going to hear is a train ride, like the train going by. But Charmaine, I sent you the link in your messenger, by the way. I haven't seen you look at it yet. Do on there. So I don't know. What is Jeannie says no court-appointed attorneys will have to step aside. Ari has private attorneys now. Well, yeah, I mean, everything's just you know what, as long as it all gets sorted out, right? I mean, like we keep talking about, who gave you the flu? I think my husband's brother did, because he has the flu too. And we've already had the flu over here, but then his brother got the flu again. So I hope we don't get it, because, it's you guys ever get the flu and you feel like you're being possessed by a demon? And it's like you got the hot shakes, cold shakes. I know you guys mostly can associate with that, but it's like I had that one time. Like I've had it a few times, but meaning one time in particular, I literally went through every possession possible. And then all of a sudden it just lifted like within 24 hours. And I was just like I felt like I went through some sort of exorcism. Yeah. And those are not pretty. Okay. And I was trying, and this is when I was like living by myself, after my divorce from my ex-husband. And it was just I had to work, right? I was, worked for the hotel. At that time, I think I was either the front desk morning manager or the night auditor at the time. No, I was a night auditor at that point. And so, yeah. And so I had to go to work. Because if I didn't go to work, I simply didn't get paid. Thank goodness at nighttime you don't see a lot of people. But yeah, but I thought all day I was like, as I was going through that, I was like, there's no way I'm going to be able to make it to work. And then all of a sudden it just lifted, after a whole night of not sleeping. But anyways, yeah. I mean, it is flu season time, and I'm not sure about you guys, but when you get the flu, that C word still comes to mind every time you get something. You're just like, ooh, like, is there like this evil variant out there again or something like that? Yeah. Drink hot water, tea, organic, raw honey, cold or flu. I've never had a flu. in my life, and it's been 25 years for a cold. Yeah, you better knock on wood. You better knock on a freaking tree right there. Here, let me just play this again as we're waiting for some things. If anyone does happen to come across something, let me know. Jen, like I said, if you happen to see something, it's pretty rampant in the UK. The C word, is it? You know, it's really hard. Like that time period. I don't want to get into it too much because I don't really like to talk about that stuff on YouTube. But you know, that was a pretty crazy time. And I hope I never ever experience that again. You know, I feel like I was walking around, like we're all walking around like these freaking, I don't know, freaking things over the PA systems are like, please stand at least whatever 6 feet away from, please wash your hands. And it felt like one of those robotic movies. And people are coming in and out of the stores with masks and stuff like that. And you're hearing these robotic messages going on. And, you know, and it felt like, I don't know, I'm old and a lot of you guys might not remember this movie, but there was a movie called The Comet. If you guys ever remember that movie, that's when a comet happened. And basically anyone that wasn't in like a metal container or shack or something metal basically would survive. And if you didn't, either you were, you know, evaporated or you turned into a zombie. And it was one of those things that when you know, as they were in that movie, it's like for miles and miles you're like not seeing anyone. It's just like that. That's how it felt when I'd go to work. And I just work literally, well, when I was working, it was literally just like over the bridge, like 2 minutes away. And every morning it felt like I was by myself in the world. Have you seen any of the responses? Are you talking about on my case? Jen, are you talking about on my case? Night of the Comet. Yeah, yeah. 1 second here. Let's see, Indiana courts. Let's see here. I know that I think he went, but I think let's see. I just want to quickly look around Twitter too here. See if no 14 no. Let's go see if Defense Diaries has, or let's see if Angela has any. Okay, that's Fox 59. Richard Allen has arrived. That was 41 minutes ago. Other than that, there's no update there. Just kind of peeking around here. Defense Diaries. Nope. What about Sleuthy Goosey? Sleuthy Goosey, do you have anything? What's this one? Nope. Hold on a second. Thanks, Tom. I cut out all the soda 20 years ago. Oh, you know, Tom, that's probably very wise. I should probably cut that out too. I mean, I have to drink the diet stuff because I'm diabetic now. I'm diabetic number 2. Sent you a screenshot that I found. Okay. Where'd you send the screenshot to, Jen? Is it in Happy Halloween? Hi, Tommy. How are you? They just posted a motion for continuance. Okay, let's just take a look. So no cameras. No, oops, I guess I should play that thing again. On there. In Messenger? Oh, there you are. Okay. Thanks, Jen. Okay, let's see here. Oh, wait.
Common and super chat. $2. Thank you. I cut out also the 20 years ago.
637.
No clue since then.
Jen, that screenshot that you sent me, that was from like yesterday. That one that you sent. That was like the, what was that one called? The right or whatever it was. Let me see what that one was called. Brief right. Is that the one? No, that's not the one. I have so many freaking documents yesterday. My head's spinning. Whoops. Is that Charmaine? Oh, I can't see us. So 1 second here. Son. Save. Update. New layout. 1 second, Charmaine. Let's see. Can I see you now? Well, I can't see myself, though. Here, let's just go back to this way. Nope, we don't want to go that way. We'll go back to this way. But hold on, let me just edit it. Let's see. Move us around. There we go. Okay. No, not at all, Eddie. Not at all. Hey, Charmaine, can you hear me?
I can hear you. How are you?
Happy Halloween. So you're an Oilers fan, eh? Is that your costume, eh?
I'm a loser.
Loser. You're a loser, baby. That's what they tell me. Okay, so let me just see here. Kelly sent an attachment. Let's see what Kelly sent me. That's the girl. But Jen, thank you. But yeah, that one came out yesterday. That one we showed. Let's see what Kelly's sending me on Twitter here. Okay, so right now it's just simply showing on Wish TV. Thank you, Kelly. Richard Allen, the suspect in the 2017 Delphi murders, has filed a motion to delay his trial from January. So that's, I guess, some of the latest going on.
The defense filed?
Sorry?
The defense filed that?
Yeah. Well, Richard Allen. Yeah. Yeah, I'm just curious, like, what's all was going on, like, if it was just simply dealing with what was, I don't know. Honestly, I'm at a loss. Are you, kind of what was happening? It was
100%. I'm curious to see who's all at court for Richard Allen today. Are the new attorneys going to show up? I think somebody said in chat that Baldwin and Rosie are back on the docket listed on my case. Is that right?
Well, yeah, I mean they put in their motion, but I'm just trying to go over to my case right now, actually, and just see what's kind of, if there's any updates going on with that. Like the filings came in this morning for, kind of like what we showed last night with Baldwin. It's like it wasn't filed yet, but now they're both filed, basically saying if they're not reinstated that they're pro bono attorneys for Richard Allen. So I'm just moving over to see if there's any order issued. Okay, I don't see anything on my case for anything for that part, but let me go over to Richard Allen's and see if there's any update on there. Oh, it's like a book. You have to scroll all the way down. So let's see here. So on the 31st, we got the appearance filed pro bono, like I said. So appearance filed for Labrado. Okay, appearance filed for Rosie, which I showed earlier. Order received from Indiana Supreme Court noticed McClelland, Baldwin, so it's like all I'm seeing is all five I'm seeing order received from the Indiana Supreme Court. So McClellan, Baldwin, Rossi, Scremin, Librado, Luttrell. That was on there. Motion for continuance filed. Let me just quickly email Faith and see if there's any more documents. Right one here. Compose. If anyone's saying anything in chat that you see, just feel free to talk.
Wow.
Okay, let me just seeing if let's put that in there. Let's see what she says. Anybody? Oops, I guess I should play this thing again. Sorry, you guys. I thought what? Yeah, you know what? I don't think so myself, Jeannie. And the reason why is not because I'm an expert. It's because after listening to Travis and listening to the prosecutor's podcast and stuff like that, like they were saying that's not really likely that that's going to happen at all. So I personally don't see it based on the lawyers' verbiage on what they were saying about it. What do you think about that, Charmaine?
I'm not sure what you're talking about. Kind of lost.
Jeannie's basically saying, I think the judge will be removed, from the case if she doesn't recuse herself. But what Travis, the lawyer that was on yesterday, was saying, and from what prosecutors, like, that's very highly unlikely that is going to happen.
Yeah, I don't think so either. And, after thinking about it, I think that the writ that they filed with the Supreme Court yesterday, I think that's going to be granted. But I think there might be a loophole where she won't have to let Rossi and Baldwin represent Allen, even pro bono.
That's my gut feeling too, to be honest with you. That's just a gut feeling thing. Yeah. I could be wrong, but I kind of feel the same way that you're just saying that as well. What do you guys think in chat? Do you think that Brad and what's his name? Andrew Baldwin, are going to be able to represent,
Said that
Richard
though,
Allen?
it's very interesting that their names are back on. They're back on listed on my case, so that's right. Maybe for this hearing. But if they do, then she'll be open to do that prepared statement in open court, like she probably should have done if that's the way she wanted to go. You know what I mean? Yeah. Like, it's gonna open them up for what she probably should have done in the first place to avoid all of this. I think.
Yeah. Well, I definitely feel, I kind of agree with I definitely agree with what, Travis was talking about. I feel like, Judge Francis Gals, that she feels like she's doing the right, things, and not, like I feel like no judge is going to go out of the way to try to personally, like, do things that go against what they're supposed to do. But I do think that she's done definitely a couple of wrong things in all this. And yeah, one of the things that probably threw me off the most, I think yesterday when we were talking, I shouldn't say the most, but is the way that she kind of like threatened that if people don't turn over these photos, they're going to be, in contempt and stuff like that. And I don't know. I just thought like that was a bit harsh. Oh, let's see. Hello, everyone. Morning, Michelle. What's happening with the court hearing? Did I miss everything yet? Oh, well, so far what we have here, I think I just took a screenshot actually. So let me just see if I can bring up that screenshot. Or well, here, I mean, I'll just share it like this. You probably can't really see it too well, but let me just take a look. Okay. No, I can't really see that too well. 1 second. Did I take a screenshot of it? I'm pretty sure I did. Yeah, okay, I did. Okay, besides some of the appearances for pro bono from Rosie and Andrew Baldwin and what's his name? Jack Luttrell or something like that, which is Nick McClelland's, just some paperwork there. Let me just share screen window. Okay, so this is what has come out so far. Sorry, did I get an email back from Faith? Faith. Okay, I got Richard Allen PDF. Okay, so let's show this. You know what? I'll just bring it into here and we'll look at the document. Just make it simpler, I suppose. Oh wait, I guess I should probably download it, huh? That would help. Go back to my email. I was too busy going, oh, okay, well, we got this. So, back over here, guys. So as you can see over there that I just had up, all the different attorneys' names were there. Okay, so come on. Oh, come on. This is why what was happening before the live. Chrome. For some reason, Chrome is acting poopy. Come on. Got it. It's the file, but my thing's giving me the salt and pepper shaker because it's bad. Close program. Okay. Yeah, close program for that. Fine. Probably just should have rebooted, but the live was supposed to start. Okay, close. Let me just go back to the actual form then. Fine. If you want to play it that way, let's do that. Appearance. This one right here, I believe. Okay. Sorry, guys. I mean, if the thing says do a computer update, I should probably do a computer update, huh? But no, I was like, yeah, no, not right now. Okay. Can you see this? Whoops, that's too big. I'll make it. There we go. Okay. Can you see that on the screen? Let me just take a look. Okay, you can. Perfect. Perfect. And let me just go to it. Okay, so motion for continuance of jury trial comes now to the defendant, Richard M. Allen, by counsel. Okay, so by counsel Librado and Scremen, and respectfully submit the following motion for continuance. Okay, so this is obviously by those two attorneys that were appointed to them. That attorney Librado and Scremen were appointed to this the case on Friday, October 27, 2023. The trial in this case is currently scheduled to begin on January 24th of 2024. Okay, is currently scheduled. The trial in this case is currently. Wait, is that a new date? Because I'm thinking because it started on the 8th. So is this a new date then? Defense counsel has not received discovery in this case, and it will be impossible for counsel to be ready for trial in January 2024. The state of Indiana has no objection as long as the CR4 purpose are charged against the defendant. Wherefore, the defendant by counsel respectfully requests that this court grant a continuance of the trial herein to a new date and time, and for all other just and proper relief in the premises. Okay, so that's by those two. Okay, so what do you make of that? So, I mean, it's by those two attorneys. So what do you guys, jury selection? Oh, jury selection, is that what it was? No, let's see here. I got the case summary open. Jury trial was set to start on the 8th. Yeah, the trial was set to start on the 8th. According to that's been my case, which we knew for a long time. So now they're saying January 24th. Hey Shane, how are you? Oh, Travis. Let's see, Travis. Just saw this. Okay, let's just see here. I'm just going to tell him quickly. Charmaine, can you just talk about whatever you want to for a second while I just answer Travis back? Just give me a moment. Just give me a moment, guys.
What's everyone dressing up as for Halloween? Or your kids? What are your kids dressing up as? My kids are grown, so they're dressing up. I just don't know what they're going to be. Shelly, it's going to snow where you're at. Where are you in the world? Inflatable shark. I love that. Ooh, you're in Indiana. Have you ever gone to one of these hearings or anything? Hey Cheryl, happy Halloween. Cold in Texas, that's not good. Mike Wazowski from Monsters, that's good. Love it. No major updates, Andy. We're just kind of waiting, kind of watching my case a little bit. There was notices of appearance filed for McClelland, Baldwin, Rosie, Fremen, Librado, Luttrell. All of those were filed, it looks like, this morning. We haven't heard anything, so we're just kind of waiting. And Sunny is off talking to her new lawyer friend, who I see is also in chat. Travis at live last night was awesome. It was amazing.
Yeah, I was just going to forward him the documents. So, Travis, this is one of the documents, the motion for continuance of jury trial. So basically, the attorney William S. Labrato and attorney Robert C. Scremen were appointed to the case Friday, October 27th. The trial in this case is currently scheduled to begin on January 24th. Defense counsel has not been discovery. I mean, I get that this is a motion for continuance, absolutely. What I am confused, or I think a little bit about, is that on my case, it says order received from Indiana Supreme Court. What just came in? Oh, wait, I don't know. Let's see. Order received from Indiana Supreme Court. And it says, like it has all of the attorneys' names on it. I wonder if I have to ask Faye separately for that document. Give me 1 second. First of all, let me just send Travis off these documents. Control. Okay. Piss off, Chrome. Seriously? I don't know what is going on. I've never had this happen before, where it literally... Close program. I can't seem to send things through. Chrome, I hate you. Like, I've never experienced that with Chrome ever, where it literally won't let me send an attachment. Darn it. Okay, anyways, what's Travis saying here? Any new more documents? Well, so besides this one here, let me just settings. I wonder if I have to request this one separately. Where's my... Oh. Maybe later. Open. Let's see here. Sorry. This one right here. So, order received from Indiana Supreme Court. On there. I would suspect that might be an order that gives people until November to respond. What I'm wanting to know is the order received from Indiana Supreme Court. What I'm confused about, actually, Travis, is, do I request that one from the Carroll County Court like I typically do with Richard Allen stuff? Because it's underneath his thing. So it's confusing when there's like these two things going on, but I think that one's to do with his. Is he the guy sitting beside Nick last week with the gray hair? The newest I just seen. Who? That Latrell guy? Okay. Order received. I gotta figure this one out for this piece of thing. I'm gonna have to send it to Faith. Let me see if I can try to send these attachments to...
Yeah, so that James David is the deputy prosecutor. Carroll
Sorry,
County.
say that again.
That James Luttrell or whatever, he's the deputy.
Yeah. Okay. Chrome can piss off today. It's pissing me off. It won't let me send Travis the documents. Never had that ever happen with Chrome. Stupid thing. Probably not if you pay for them. Order it, and I'm sure. This one right here that's in front of us, order received. Hey, Sierra on there. So, I don't know. Is there any question you want to ask Travis while he's in chat, Charmaine?
Last night I had so many, but right now my mind is kind of blank.
Well, mine's trying to be like octopus arms here, trying to do the live, try to email, try to send. Chrome's acting like a piece of crap. Just trying to see what updates are going on out there. So yeah, so tell me about it. So my brain right now is like, it's like all over the map here. This case is spooky. Well, don't forget, you guys, it's Libby's favorite, of course, I don't want to call it a celebration, favorite holiday. That's what I was looking for, a holiday. So make sure you guys give this live a like if you guys don't mind. You guys, it helps put it into the algorithm, of course. But you know what? Let's do this one for the girls first and foremost, and justice for the girls in support, of course, of Libby's favorite holiday, which is Halloween, and like I said, truth and justice at the end of the day. That's what we want from this. I know, like, all the stuff that's going on will sort itself out. It always does. Everything always works out. Doesn't matter. Sometimes the way it's supposed to be, and sometimes people don't agree with it. But at the end of the day, it's, you always know things are going to happen the way that they're meant to happen for whatever reason. And as long as, like, this stuff will get sorted out, and then hopefully, like I said, like, the case can just move forward towards, some justice for Abby and Libby. Yes, it is. Yes, it is. Absolutely. On there. So let me just, I'm just going to quickly email Faith again, if I can here. Well, hold on. I'm going to stop the screen just so that you guys don't get bored looking at that. And I'm going to put on that video for you guys that haven't seen it. And I'm just going to play this for a minute out. There's no sound to it, guys. But, this is Richard Allen arriving to court. Thanks, Gen C, for sending the link over.
Do we see Rick Allen in this?
Yes. Okay, the order was the one about November 9th. Okay. Adam's trying to talk to me on messages here. Okay, let's see here. So, okay, thank you, Travis. Okay, thank you very much. Travis he says he's on a jogabout, basically, or a walkabout. And that's why he's can't join us at the moment. So he said he would be in chat to answer. Oh, there's Alexa. Good morning. They're saying that Rosie and Baldwin were kicked out of the case. Well, Charmaine, are we going to be shocked?
Nope.
Nope. We're not going to be shocked. Oh, Deb just got that too. There we go. There you go. If anyone, Deb or Alexa, if you guys have any Twitters or media to share in, just send it to me on Messenger if you could, so I could show it. About their appearance, okay. But Rosie and Baldwin were okay. So, not a shocker to me personally. I had a feeling that was coming, just like what we were talking about earlier. So I think, okay. Thank you. Thank you. So let's see here. Whoops. Let me just go back and play that. Okay. So what's your thoughts on that, Charmaine? Yeah. Do you think, do you think it's the right thing to do, first of all?
I mean,
Yes,
I have no idea anymore. My own opinion, I've always thought that Baldwin should go away and go away quietly. But Rosie, I think staying would have helped the case keep moving. But I mean, I don't know. I kind of thought that happened today. I thought she was just gonna say, okay, you can appear, just so that I can do this officially. So
yeah,
and
I just seen it.
when I first came on.
Okay, hold on a second. I'm just Docs Pop is coming in again. I'm not sure what it is. If there's another Docs Pop, Adam or Deb or somebody that's, I'm looking at it, but I'm not really seeing anything at the second here. Sorry, Charmaine, to cut you off there. All of a sudden, as you're talking, Docs Pop went off, which is the alert for Richard Allen. It's about to get messy. Well, okay, so Travis, if you're listening intently, so if Baldwin and Rosie are say kicked off the case, I would like to know perhaps what the next steps are that might happen. Like, can they? What happens? What happens with that now? To be honest with you, or do they file a motion for, something else? I don't know.
And does anything change with the Supreme Court? I don't think it will, because those other lawyers filed it, but I don't know.
Adam says, I'm hearing the judge approve the new trial date for October of 2024. Okay, there must be something out there. Let's see here. Let's look. There's got to be something out here on frickin' Twitter land or something. If you guys are all telling me this, you guys are getting it from somewhere, perhaps. Anybody? Deb? Anybody? Oh, Frank. Did Frank say that? Okay. So Frank's at court, Frank Meister. So again, I guess RA filed a motion to, right, he did, Alexa. We showed that one already. There we go. Frank just called and they kicked Rosie and Baldwin off the case in court this morning. Okay. I'm just curious what the next, how it will unfold now, with Baldwin and Rosie. Because of the whole pro bono thing. Yeah. Like, I thought that if they were pro bono and were doing it, that really the judge couldn't have much to say about it, but that's where, Travis knows the law. Yeah, whoops. Yeah, a whole year. But you know what? It's better than year 2025, even though, to be honest with you. We'll see. Okay, let's see. Adam sent a photo. Let's see. What did Adam send? Okay, let's see what Adam sent here. Okay. WTHR. Let me bring this stop. We'll bring this photo in and read what Adam just sent here. It's not that. Whoops. Oh, please.
I think you're right, Alexa. I don't think this is the last you'll hear of at least Rosie.
I feel like no, but we'll see. We'll see. So it says here, let me just make this bigger for you guys. Okay, so thanks, Adam. Alan's, sorry. Alan's trial is currently scheduled to begin January 24th of 2024. According to the filing, the prosecutor has no issue with the trial. Wait. Okay, Tuesday's hearing started 40 minutes late. The judge told Richard Allen, I cannot and will not allow these attorneys to represent you. Oh, okay. Then she disqualified Baldwin and Rosie from representing him, even pro bono. New attorneys set a trial date for October 15th to the 31st, of 2024. The new attorneys have not talked to the state yet. A return of discovery is coming by the end of the week. Baldwin's attorney spoke to the judge about his disqualification. He said the judge did not give them notice of the alleged gross negligence on the defense's part, so they were not prepared for the ruling on them not representing Allen. He said the judge's summary ruling violates the Constitution and is unfair to Richard Allen. This is the breaking update. Okay, so that's what we have so far. Let's see here. Travis, can you come off your walk now? An appeal by Indiana to the Indiana Supreme Court. You know, I mean, do you feel like this is the last of them, Charmaine? I don't.
No, I don't. Like I keep saying it, I hope, because Baldwin is responsible for what has happened. He's responsible for this whole mess. He should ethically and morally go away and go away quietly. But I think Rosie has a leg to stand on. I do, and keeping him on the case, I think, would help it continually move forward. I don't know that he's done anything egregious enough to be removed. So, but having said that, I have no idea what remedies are open to him. You know, Travis, maybe you can.
Yeah, Charmaine, tell these lovely people that are watching to hit that like button for us. You know, I'm at for this one. Always unselfish reasons, but for this one, do it for Libby. This is her favorite holiday. Do it for the girls. Do it for justice. You know, and hopefully later on the other live or whatever when we're doing Halloween, maybe perhaps Travis, I'll ask him if he has time, you know, to join us to talk about it. You guys, always too, you guys know that we've talked about the Defense Diaries and the Prosecutors Podcast, which many people, it's funny because, you know, because of them covering this case now, like they're getting a lot of people, you know, going to them, of course, because a lot of this, like when Travis coming on yesterday, you know, the appreciation is so awesome and great for when someone can come on that has the experience to help us understand it, you know, in their verbiage that they speak properly, but dumbing it down for us so that we understand it. That's what I love most about, especially Brett from the Prosecutors Podcast. You know, he always does a really great job that you walk away feeling like you understood exactly what he was saying in a sense, you know, and you walk away feeling a little bit smarter each time that you come away from listening to these attorneys and that talk about it. And it's always nice hearing from the defense side and the prosecutor side and seeing what they're both saying. Judge Gull has a huge ego. It will be a problem for her going forward. Hate me or like me, I like Fran Gull myself. You know, what do you think of Fran Gull? Like, are you like, do you think she's doing a good job? I mean, knowing that everyone maybe doesn't do the right things, but I don't think it's intentional. I don't know. I really feel like she's getting like the short end of the stick in a lot of ways. That it's kind of like what I feel like is people are judging so fast in a sense, and it's like it reminds me of like ants that go, oh, this information came out. Oh, Judge Fran Gull, right? She's the worst, you know, judge. Get her off. Da 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 da. and stuff like that. And then there was the ones that, that really like what she's doing in a sense. And I don't know. What do you think about her? Any opinion?
I honestly don't have an opinion on the judge because I don't know the law or like the process that she's supposed to follow. And I just like to say that as much as I love Bob and as much as I love Brett, you go there and you hear the one side, the defense side or the prosecution side, and they're so extremely different. That's why I appreciate Travis so much, because he's exactly where I am. He's middle. He's going to tell you both sides of it, the good and the bad for both sides. So if you're only watching defense diaries, then you're going to be pro-defense. And if you're only watching prosecutors, you're going to be pro-prosecution. But Travis brings something else, and I think that needs to be recognized. I really appreciated that live last night.
Yeah. Let's see. Charmaine is correct that current right is unaffected by the evening's event. Okay, let's see. Alexa's sending me something from Wish TV here. Let me just go take a look. The Wish TV news. Okay, let's see. I guess got to pull it up here. See if does this have an audio to it?
The whole time has been, I'm not worried about Richard Allen being the guy or getting to trial or getting convicted. I believe all of that is in the works, but all of this is just creating fodder for an appeal later. And once you have that, then it doesn't matter that you've got a conviction. The families are still going to be going through hell for years and years and years and maybe decades.
Oh, absolutely.
It has to be done right. And that's my only gripe with all of this.
Same. That's what we were saying like last night, or when I was giving my final thoughts. I mean, like Abby and Libby, the families, those are at the forefront of all of this when it comes to frustration and stuff like that. Like as for the court process and stuff like that going on, like I'm not one of those ones that really okay, I was not expecting the whole 136 page thing coming out. That one kind of was like, what?
Can I interrupt you for a second? Deb said if you for Frank, he'll come up and report for you.
Yeah, Frank.
That would be awesome.
Frank? You want to come up? Let me just send you the link, Frank. Be nice to hear from you. Copy, and I'll put it in the messenger. Okay, Frank? Just give me a second. Let's see here. Where is Frank? There's Frank. Paste. Okay, I send it to your messenger, Frank. Okay, and I think we're going to have to go to that layout, but I think 1 second, edit. Move this over. Wait for Frank. Hey, Frank, you got a nice pigtail there, buddy. Oops, put you back over there. And we'll wait for Frank to come up and join us here. Other than that, well, update layout, 3 people. Okay, let's see. Sorry, you guys. It's really hard when you're the creator and you're trying to do a bunch of different things at one time. So forgive me. The exact thing happened. Yeah, the Ramirez case. Oh, what you doing underneath my foot there? Sunny, drop a link for Frank. Okay, I dropped the link. Channel 18, actually the local channel, but I guess all of them are there, so probably don't matter. You skipped over what happens next. Look for 1 and 2 above. Did I miss something? Oh, this one right here. Yeah, no, I had that one up, Travis. If they think that they have made a sufficient record for appeal, nothing more on that. I think it's like yesterday when Adam read that whole thing and then Travis said, did you? But yeah, I did have this up already. If they believe the court, but you know what? We'll say it again. So, one, if they think that they have made sufficient record of appeal, nothing more on that. If they believe the court is required to allow them to represent Allen, they will file another right. What's Alexa sending me? Oh, there's Frank. Motion for continuance filed. Yeah, got that one. Hey, Frank.
What's going on, guys?
Hey, it's happy. Oh, Frank, I'm coming in. I'm coming through your phone.
I got if I cut out, guys, it's because there's only 4G signal out here in Carroll County until we get to a certain spot.
Okay.
So if I get cut off, I'll hit you guys back. But Fran Gold put Rosie and Baldwin in their spot real quick. On the 19th, said it was changed in 12 days. Because, Mr. I'm sorry, but I can't allow because of this.
Oh, Frank, you're cutting out really bad. You're really bad.
Hold on.
Darn it, you're cutting out really
Try
really
to get a better signal.
Darn it, you're cutting out really, really bad.
Can you hear me?
Yes.
Really not.
Yes.
Can you hear me now?
Yes. Yes.
Okay. Then David Hennessy got up there and basically was bitching at the judge, telling her about the Sixth Amendment right and all kinds of stuff, and telling her she had no right or legal right to do what she was doing and all this crap. So this is really going to hit the Supreme Court before anything. New trial date is set for October 15th through the 31st of 2024.
Yeah, I've seen that already.
So that was basically it. We were maybe in there 15 minutes when Judge Gold got in there, and it was over. So
Frank,
that's about it, guys.
I know I'm coming
What's
in
that?
through your. I know I'm coming in through your speaker. I'm hearing my own voice. But can you say what you said at the start?
What's that?
Can you repeat what you said at the start? You cut out.
Asked Rosie and Baldwin, so what happened from the 19th or 12th, or between the 19th and today when you recused yourself? What changed everything? And that's when Rosie got up and made his spill. There was no gross negligence and all that shit. And then she asked Nick McClelland, do you have anything to say? And that's when he came back and said there was total gross negligence in this case. He said there's no way around it. Well, then David Hennessy gets up there and really basically started bitching out the judge, telling her that she was wrong. She had no authority to do what she was doing. It was just almost a shit show.
Okay, you're cutting out again. Turn off your video, maybe.
I have a question. Yeah. He's back.
I think he's froze.
Yeah, go ahead.
I think he's froze.
Alexa. Hello?
Yeah. You're froze, friend.
Yeah, we're in a bad area, guys. Wait, if you guys are still on in about 20 minutes when I get on the interstate, I'll hit you guys back.
Okie dokie. Okay. Thanks, Frank.
Okie dokie. All right.
Okay. Thank you very much, Frank.
Let me hang up.
Okay. Thank you very much.
Yeah, it's not letting me hang up.
Here, one second. Here. Oops. I was just about to end the thing for him. Okay. Yeah. That was kind of hard to hear. My voice was coming back at me. And Frank was, of course, lagging there at the end of the day. Not his yellow journalism. Honestly, each to their own, to be honest. I appreciate Frank. and he was sending a lot of documents yesterday. Frank's a good guy. But I get what you're saying. But sometimes let a person be who they are, and that's just how Frank is.
Yeah.
What the fuck, So, anyways, Charmaine, were you gonna say something? But what were you gonna ask?
I'm really curious to know if the Supreme Court filing was acknowledged in open court. You know what I mean? Like,
right.
And I think I heard him start to say something about it. He was breaking up so bad, though. So, and
I know.
I don't have anything against the murder sheet. Don't get me wrong, but I don't know. I would rather hear what happened in the courtroom from somebody like Frank than to listen to an entire podcast about an 8-minute hearing or whatever it was. Do you know what I'm saying? No shade whatsoever. I just want to know what happened, and I don't want the snarky remarks and everything in between. I don't know. That's just me.
Has anyone heard anything yet, Starco? Okay, well, so far what we've heard is that Rosie and Baldwin were kicked off the case by the judge. And then I guess it's really too about, like to see what can get away with giving the judge a tongue. Hennessy can get away with giving the tongue a lashing, yeah? Now, about making up stuff, and yeah, I was gonna say, like, Frank was just saying again what was happening there, even if it's in his own colorful language, in a sense, or I don't know. Like I said, I like Frank. He reports his way and says things and whatever. I like the fact that he's there, going in and stuff like that. There was a few people that were there, but at the end of the day,
everybody has the right to, none of us are sitting in the courtroom. So I personally appreciate Frank's time and his dedication to the case. He goes to every one of those memorial walks.
Yeah.
If you don't like Frank, that's right. So don't watch him. It's that simple. I don't think we should, calling him out or insulting him in any way. He's a person with an opinion, and he's got a right to it. So.
No, absolutely. Again, sometimes it's not everybody's cup of tea and stuff like that. And, but whatever, anyways, this article here, Alexa had sent, let's see here. So is there no video? There doesn't seem to be a video. Okay. So it just simply seems Delphi Murders files motion for delay, which we've already seen. Richard Allen suspect filed the motion for delay. Attorneys filed the motion Tuesday morning. Allen is currently set to go to trial in January on 2 counts, right? And it was moved. Today's hearing comes after Allen's new attorney's request to unseal more than 100 Okay, so what does this say? Today's hearing comes after Allen's new attorneys requested an Allen County judge to unseal more than 100 documents in the docket, including a theory that the murders of Williamson and Germain were part of a ritualistic sacrifice. His attorneys filed the motion with Indiana's highest court on Monday, arguing that the Carroll County prosecutors violated Indiana's open records rule for court proceedings. Judge Francis Gall has allowed Allen's original defense team to rejoin the case. Wait, what? Hold on. Wait, what? Judge Francis Gall has also allowed Allen's original defense team to rejoin the case. Judge Gall had previously ordered Andrew and Baldwin and Brad Rosie removed from the case, saying they had withdrawn. Is that what? Why am I reading that wrong?
Nope.
So wait a second. I'm confused. What?
Travis said something here. So to get to Indiana Supreme Court on removal of Baldwin and Rosie, as excellent recap by Frank, is 1, an interlocutory.
I heard that yesterday. Yeah.
It was
Interlocutory.
a writ is filed. Great job, Frank. Can you dumb that down for me, Travis?
Brett was talking about that word actually yesterday on his podcast. That's the reason why I remember it. All right. Well, this is what I'm confused of. Because this case says Judge Francis Gull has allowed Allen's original defense team to rejoin the case. Judge Gull had previously ordered Andrew and Brazzy removed from the case, saying that they had withdrawn. Baldwin and Rosie claim that the judge carried out premeditated ambush and coerced withdrawals. They have asked that she step down from the trial. The pair will now serve Allen pro bono, meaning that they will not be paid, and will work alongside his new court-appointed attorneys. If the motion is approved, the trial will be delayed from its current. Okay, I'm just kind of confused. So is that old news?
No, I don't think it's old news at all, but I think it was because she allowed them to appear on behalf of Rick Allen today. And like we said, first thing this morning, she did what she did. She allowed them to represent this morning so that she could kick them off officially like she should have done in the first place.
Right. Okay.
This morning.
Okay. So that's why it's like, okay, the apparent, but it says the pair will now serve, but that I think it says the pair will now serve Allen pro bono, meaning that they will not be paid and will work alongside. If the motion is approved, the trial will be delayed.
Morning after they filed, or I don't know if they filed, but the notice of appearance, right? And then that was approved or whatever, that was granted. They were allowed to appear this morning for the sole purpose, again, so that the judge could open court remove them.
So are you saying that even as pro bono, she allowed them to serve to boot them off in a sense?
Yeah. Now, whether or not Travis would know whether or not she can do that in the eyes of like the Supreme Court, yet to be seen, I guess.
Okay. That just kind of confused me reading that.
I think this book confuses me in my mind as a bunch of jello.
Yeah. Yeah. Okay, so let's see here. Okay, so I'm just trying to look and see if there's anything there. Okay, Bambi, you need to shush. Richard Allen. I'm just trying to see if there's anything else added. Besides, okay, they got the new court dates up. I mean, you know, from the 15th to the 1st, actually, of 2024. Motion to continuance. Okay, we saw that. Okay, so everything we've seen already. I think it's a reporter who has no clue. Yeah, like I didn't enjoy reading that. Let me put it that way. Just a one-off. As I understood it, Rosie and Baldwin are out for now. Are his grounds for an appeal? The Supreme Court will be involved. Yeah, that sounds more accurate there. Let me just quickly go over to. I want to go over to Twitter here, see if anything's going on. Okay. With let's see what Wish TV. Do they have anything going on? No. No. Okay. Let's see here. Get well soon. Yeah, feel better, Shelly. On there. Sorry, just trying to get back in here.
I'm a little surprised that Auto hasn't posted anything. Probably Twitter, but.
Well, that's what Defense Diaries. Let's see.
Because he went to Delphi last night, so he could be at the hearing today.
Yeah, I know. A lot of people were, weren't sure if they were going to go or not, if it was going to happen, or if it was going to be like, a waste of time, because like I think for Bob Motta there or whatever, I think it's like a 4-hour drive for him. And then, right, just like Stuffa when they went and they got 3 minutes on the last one there. Again, to anyone coming in, happy Halloween. Again, Libby's favorite holiday. Please give the live a like and a share. I feel so bad for the families having to wait another year. I know that we feel bad, but I also know that the families as well, that they want justice done the right way. And
This is
if
all.
it's been,
It is
Go
all
ahead,
connected to this issue right now. It's not. I don't want to say this because it's going to piss a lot of people out, but this situation right here, we can't look at it as being about Abby and Libby. It all is. I get that, but this right here, this whole delay thing, and the Supreme Court and all the shit that's going to be going on, it's unfortunate, but we can't look at it as delaying for Abby and Libby. We have to look at it. We got to get it sorted out for Abby and Libby. Do you know what I mean? I know it sounds bad, and it's all about Abby and Libby. Yes, and you know that I feel that way, Sunny, but this all has to be sorted out to make sure that things are done right. And
that's exactly it.
It's going to be appealed, and everything could be overturned on appeal already. Like, it's already such a freaking mess. So,
well, like I said, I know that people, like are, like feel let down and like that all this stuff's going on. But I know, like Becky, whenever I've talked to Becky, she wants justice for the girls. And if this means that this takes, more time for that to happen, then I know that she'd be that they're fine with it, because again, you want the justice for the girls. Like, that's the end thing. So like what I was saying earlier, right? The process is going to work out the way it's going to go out, however it happens. My, is that sky ever very orange this morning? I guess it's very fitting for Halloween, is that sunset. It's like, I'm looking out my back window or my bedroom window, and it's just like orange as day. But anyways, as long as hopefully at some point we get to the proper justice for Abby and Libby, in which case they deserve. And it's a roller coaster ride. Absolutely. Now, just quickly, Alexa sent me this, so let's listen to this. I guess, let's see here, from WTHR. So I'm just going to play this out for a second. Let's see. Hopefully there's no ads. Please don't be any ads. Oh, there's an ad. Okay. Skip ad. Yeah, let's skip ad.
Just 3 hours. Another step
Oh,
in
wait,
the Delphi
we saw this
murders
one already.
case. Richard Allen.
We saw this one already, but okay, don't worry. We'll play it out. Alexa, this is the one you sent, right? Is that the one you sent? Hold on a second. Yeah, that's the one she sent. Hold on. I'm gonna. That's the one that WTHR. Anyways, let me just play this one out for a second. But that should be the one that Alexa just sent. But we already played this.
Delphi murders case.
Richard Allen, the man charged in the deaths of Abby Williams and Libby German, will be back in court in Carroll County. Samantha Johnson is live there this morning. Sam, a lot of new information over the past few days. What can we expect there today?
Well, Julia and Julia, we are expecting a big crowd here today. In fact, you can see there's already a few folks lined up here at the door. We just saw police come through with their canine crews to do a security sweep. This will be the first time we've seen Richard Allen in more than 4 months. We do expect him to be here in person for today's hearing. The bigger question, and perhaps the main focus today, though, might be who is going to be.
Okay, hold on. I'm going to minimize that. Because I think it's about the article more or less. Is that like they have that video, but I think it's more about the article. So I cannot and will not allow these attorneys to represent you. Judge disqualifies Richard Allen's former attorneys. Sets new trial date. Andrew Baldwin and Bradley Rosie. I told the court that they now plan to represent Allen as pro bono attorneys if the judge does not reappoint them as public defenders. Tuesday's hearing started 40 minutes late and centered around disqualifying Richard Allen's former attorneys from representing him and then setting a new trial date. Allen is accused, of course, of the killing of Libby German and Abby Williams in February 2017. During the hearing, Allen's former attorneys, Baldwin and Rosie, were sitting next to him, and his newly court-appointed public defenders sat behind him. The judge told Richard Allen, "I cannot and will not allow these attorneys to represent you." She then disqualified Andrew Baldwin and Bradley Rosie from representing him, even pro bono. "I'm sorry that this has happened, Mr. Allen," Judge Francis Gull then said. Baldwin's attorney spoke to the judge about his disqualification, so that the judge did not give them notice about any of the alleged gross negligence on the defense part, so they were not prepared for the ruling on them not representing Allen. He said that the judge's summary ruling violates the Constitution and is unfair to Allen and his defense. Baldwin told the judge Allen has asked us to represent him. Rosie then said to the judge, "We are on a different page on how we acted." The state told the judge its concern is for Allen to have a fair trial. Allen recently appointed public defenders asked the judge to push back his trial date, which they did, originally set for January 24th of 2024, but now is set back to October 15th and 31st of 2024. In a filing, Allen's new court-appointed attorneys, Labrado and Scremen, noted that they were appointed to the case October 27th and have not received discovery, stating it will be impossible for the counsel to be ready for the trial, of course, for January of 2024. Allen's attorney said that they have not talked to the state yet. A return of discovery is coming by the end of the week. The prosecutors did not object to appointing new attorneys or moving the trial back. 13 Investigates has learned that 2 attorneys who were Richard Allen's original defense team in the Delphi murders case filed appearances late Monday to be officially back on the case. Allen is accused. Okay, we already read that. Okay, they're just repeating themselves. They have time to put on the case. Okay, we've already seen that part. And this is the one, I think, where he's going in. Is that, oh, come on, commercials. We don't need you.
Canadians have can-do spirit.
Yes,
So does
we do.
GoDaddy. Need a domain from GoDaddy that means business.
Do we need a GoDaddy, Charmaine? I'll just make that bigger and play that for anyone that hasn't. That's Richard Allen when he was arriving. I think Richard Allen will be just fine myself. He's not looking quite as, I think he'll be just fine. Absolutely. He looks like he's put up weight back on. Yeah. I think that if he connects with the new attorneys, he could. And right, absolutely, Jen. So I guess probably. Oops, I guess we don't really need to listen to the noise of that, do we? I guess probably now, really, it's just a matter of waiting to see what new motions or filings come out after today. Or some might come out today again. We'll just have to keep an eye on that and see what's coming out. But that's pretty much probably what's going to happen, eh, Charmaine?
Yeah. I mean, that's all that can happen. I mean, Travis would know too, does the case move forward with the new attorneys while they're still pending motions at the Supreme Court level? And
Canadians have can-do spirit. So does GoDaddy.
Oops, my bad. Sorry.
What will be held up? And I mean, just the timeline, that's what I'm asking right now. Does the trial with all of these motions and stuff with Gull and the new attorneys, does that proceed now? Or does everything have to stop until the Supreme Court?
Charmaine, can you give me 1 second?
Yeah.
Just give me 1 second. I'll be right back.
Apparently, I don't know how to say your name, Miss Mala. Apparently, because that's what happened this morning. So, and I mean, I have so many questions about the Supreme Court level. What are the options now? Where does Rossi go now with the Supreme Court? Because everything that's in the Supreme Court right now, I don't think has anything to do with them, their representation of Richard Allen. And in the meantime, if this trial and these motions are allowed to proceed with his new counsel, then at the end of the day, what's the point in going backwards, trying to get back on the case after that time has elapsed? I hope I'm not confusing anybody, but hopefully Travis is still listening and he can speak to the Supreme Court filings a little bit and how that kind of plays into the trial proceedings, because all of this is part of Richard Allen's trial and due process, right? So Jen, we love talking about mental health, so anything you want to say, I'm sure Sunny will highlight it and we'll read it. Mental health is kind of present, I think, in everybody's life with struggles, especially nowadays, and a lot of us have seen and been through our own struggles or struggles with people that we know and love. So anything that you want to say or talk about?
Take care, butterfly. Yeah, absolutely. To me, what I love about people is, like I said, we all have different personalities or different experiences, or in our jobs. And like I said, so a lot of people bring in our chat and stuff like that, bring a lot of good information to the table that like mental health stuff talks about it, like Jen C's just saying, like you or like Travis, just a different, like I said, it makes for a well-rounded conversation, when people have experience, especially in that, certain area that they, have made a career out of and stuff like that. I like well-roundedness like that, different opinions, different thoughts, but definitely, like you said, right? I think all of us have, definitely mental health issues going on, some, different than others, I think, for sure. But I think everyone struggles with different things, regardless of what it is. As for Richard Allen, I mean, to me, it's just normal that someone sitting, regardless if it's jail or prison, at Westville or the county jail, anyone that goes into that type of shock, in a sense, when they are taken from their everyday life of having freedom, and then they're, regardless of, say, guilt or innocence on this part, but regardless, I think it's a normal thing for sure that anyone's going to struggle, and why he lost weight, and refused to eat and was eating paper and stuff. I mean, you're in a cage. Your life is basically stripped from you, and like I said, so Richard Allen seems to be on like his weight, going back up. And don't you think, Charmaine, that, like I said, definitely at the start, it's definitely a shocker, right? What happened to Richard, like for Richard Allen. But then, just like, I don't know what, it reminds me of Koberger in the sense of, and then after time goes on, you realize kind of like this is your life at the moment. And it's either you can sulk, or deal with it in a sense. But knowing full well that there's nothing fun about being in a prison cell, jail cell, being told what to do, how to do it, what you can do and stuff. I don't know.
And I mean, devil's advocate here. Let's pretend that we know the fact that Richard Allen is guilty.
Yeah.
He's sitting in prison and he's watching all of this going on, and he's listening to his attorneys. And I mean, we assume that he hasn't told his attorneys that, yeah, I did it. So he's watching this fight go on, and is he loving it? Do you know what I mean? Like, is he pissed off, of course, that he's being like, that he's in prison, but at the same, because he was free for how many years? He got away with it for how many years? But I mean, if you think of it from that point of view, it's kind of disturbing, really, to think that he's probably just sitting back, relishing and loving all of this. But then on the flip side, if he's not the guy,
yeah,
that would be devastating to anybody. And when he's losing weight, yeah, it's a shock that he got caught after so many years, and he thought he was so smart, and he's been forced to detox himself, and he's depressed and probably mental health issues. And we all know that if you're spiraling in a mental health decline, you're probably either gaining weight like crazy or losing weight like crazy. Acting out, the stress, the no alcohol, whatever else he did in his day-to-day life has been stripped from him. Of course he's gonna drop weight and look sick, because that's what's happening in his brain, right? So
yeah, I don't, Steph, I don't think either one of us said that what's at all, to be honest
no,
with you.
I said advocate. I am one of the only people that I know personally that has said Rick Allen is guilty, and we should just. I'm firmly on the fence there. I don't know. The PCA did not prove anything to me, nor does it have to. But I'm just saying he needs to go to trial, and he needs to be treated fairly and tried properly, so that he's not, putting the family through hell for years and years and years. He's innocent until proven guilty, and I truly believe that. Truly.
Steffa doesn't think he's getting his due process.
He's not, 100%. He's not.
That's a right, whether guilty or not guilty, even more of a travesty if he is innocent.
Even if he's not innocent, he has the right to due process. He has the right to a fair trial. He has a right to all of
absolutely.
All of this noise right here is trying to ensure that, but unfortunately, in my opinion, it's doing the opposite. It's delaying things. It's keeping things secretive. But my point is, like, let's just pretend for a second that he's guilty, and we know it.
Right.
He's probably having every second of this, and if he's innocent, how terrible. And that's why this is so important.
Yeah. I mean, bottom line, still to me, the bottom line is he's in there because there's probable cause for him to be in the system. Now, it's just really
low bar, though. It is such a low bar. I have probable cause every day for some stupid shit.
Correct.
I'm just saying, you can't convict. That's why just because you have an arrest, that's why it's not a done deal, right? That's why they keep on investigating, because probable cause is not beyond a reasonable doubt.
So I say beyond a reasonable doubt.
And that's
like he's in there because there's a bullet. He's in there because he said he was there. He's in there because of God, I can't even think of all the different things, but meaning that, at the end of the day, it's your guys' process over there in the United States. Whether people think it's fair or not, like, this is your guys' law system going on at work, so regardless, it really sucks if somebody is innocent and has to spend that time in the system. It really saddened me, because just to go off track for just 1 second, I was watching this guy, and he was on X Factor, I believe it was. And his story behind him was that he was in prison for 30 years and he was innocent. That's 30 years you will never, ever get back. There's nothing that can ever take for someone to be in the system that is innocent would absolutely be a travesty to justice. it happens, of course. Regardless, to me, with Richard Allen, again, to me, it's just the process playing out, with your guys' system. He was arrested. He is,
And
being
honestly,
tried.
Canada is the same when it comes to due process and probable cause and reasonable doubt. It's all we have so many huge differences, and mostly around search and seizure and search warrants and stuff, but probable cause and reasonable doubt are the same over the border. It's the same.
So again, for me, I'm just, send me the link. Send me the link here, StreamYard, if you can. Oh, Travis, can you hear me? If you can hear me, I sent you the link already to your email. If you can hear me. Okay, you little kitty cat, you just hush your mush over there. Hold on. Oh, I
Miss
thought I
Molly,
heard him.
I'm on the same page as you. I'm just, this whole thing has got me scared to death that any kind of conviction could be overturned on any one of these issues. And it's hard to think about how many cases, I don't know about you guys, but how many cases do we watch, especially death penalty cases? If somebody gets the death penalty, they sit on death row for years, going through like appeal after appeal after appeal. It's just, and it's going to happen anyways, but this could end up overturning a conviction. It's terrible to think of, that the families won't have peace for so long. Exactly, Miss Muller. What are they worried about with that search warrant? Like, what are you worried about? If it's just the bullet, I say bring it. Right? If you've got your experts, bring it. But there has to be something. There has to be something more.
Charmaine, give me a second. I'm just going to try to send Travis the link here on the phone, but it's a little bit okay. I'll send it to my messenger is what I'll do. I have to go about it a different way. So, because I think Travis is going to hop on with us. I'm not sure if you still have time to, hang out on the live or not. I'm not sure what your day's looking like today.
There's only a couple of people today. I just go off. If Travis is coming on, I'll probably just hang out in the background. So I love listening to lawyers.
And you probably have some things that you want to pop at them, but let me just, I just gotta do this the long way around. So messenger.
That everywhere, Jen. It's not just Indiana, honestly, but when I was younger, when DNA first started being used and talked about a lot, I thought that it was just a matter of time before there would be no such thing as a wrongful conviction anymore. And there are people out there that say that DNA isn't as that. Some people actually say it's junk science, which blows my mind. How can that be? But I guess there's always two sides to everything. But that's why we just trust that the process is going to work, and that's why the Supreme Court filing, in my opinion, is so important, because nobody truly understands what the law is in Indiana. But from what I understand, in a lot of other states, this case is so secretive that it's illegally. And that's what I said the other day on the live, that if I was a citizen of the United States and it was my right to know this stuff, and I would be pissed. But I don't know what the law is in Indiana. I don't know. Maybe Alan had a lot of unrelated porn and questionable searches. And I heard something last night about that too, about maybe the phone that one of the phones that he had maybe had been powered on.
Yeah.
On after. That's kind of the person was waiting. Let
Oh,
them.
let's see. Travis. Hey, Travis.
Hello, can you hear me?
Hello.
Hi,
No,
Travis.
we can't. Just kidding. We can hear you.
So I don't mean to interrupt. Finish what y'all are talking about, and
You're,
whenever you're ready
No, we're waiting for
for me
you.
to talk about the legal, I'll be happy to jump in.
we are
Yeah,
literally
absolutely.
waiting for you. So you go. You go. I'm muting myself. You go.
I'm gathering you wanted me to comment on what would the next step would be, and Charmaine's kind of asked another couple of questions and also answered a bunch. Is that right? What happens from here?
Yes, that's definitely a question.
Okay, so what happens from here? Based on the excellent reporting that you've been getting from people live as opposed to local news outlets, what you've been getting live, for example, from Frank seems to be very accurate. And I agree. I like his style of reporting, if you will. Anyway, we, to the point, no shading. We heard she came out. We kind of heard the sequence, and that Hennessy finished up and basically told her, in his view, she hadn't done certain things, so he was making a record. So where we're at now, as of now, we have two things. What's going to happen with Baldwin and or Rozzi, and then there's also a pending, possibly, a motion to disqualify. So let's talk about the status of the lawyers right now. If they feel that they've made a sufficient record to preserve the issue, and the issue specifically is the denial of Richard Allen's Sixth Amendment right to counsel of his choice. That's the issue. If they feel that between what's been filed up to this point and today's hearing, for lack of a better word, there really wasn't a hearing, then they feel they have an adequate record for appeal, nothing further will happen. The case will eventually proceed to trial, from what I understand, currently scheduled for next October.
That's correct, yeah. And
Setting it out a year is perfectly appropriate. And so nothing more will happen. If they feel that more needs to happen under Indiana law, that the issue maybe isn't properly preserved, or they strongly feel that they should be allowed to continue, then they may file what's called a interlocutory appeal. Interlocutory. And interlocutory just means an appeal during the middle of the case. And typically you're not allowed to appeal until you've gone through the process, there's been a trial, there's some sort of a judgment or sentence, and then you appeal from that. Generally, the rule is you cannot appeal until the case has been concluded. There are certain very limited exceptions that are spelled out in each state in what situations you can file an interlocutory appeal. Because what an interlocutory appeal does is it stays the case until the proper appellate court can review the issue and make a decision. So however long it takes for the appellate court to review the briefs, have oral arguments if they want oral arguments, and then come to a decision, this criminal case would be stayed, fancy term for put on hold, temporary hold, until the appellate court ruled. That's why they're only allowed in certain limited situations, because you can't be shutting down a criminal case every time either the defendant, especially, or the state decides, oh, I'm gonna appeal this decision. So, for example, the denial of a motion to suppress is almost universally not allowed to get an interlocutory appeal, because they're brought up in almost every case, and in almost every case they're denied. So you don't get an interlocutory appeal on a denial of a motion to suppress. So that's one option. If they feel that they have grounds, they can file an interlocutory appeal. The other possibility is if they feel that the judge was required to do something that she didn't do, then that's grounds to file another writ of mandamus and or prohibition. And remember from the talk last night, to file a writ, it has to be something that the judge or the clerk of the court is required to do by law in order to file that type of an appeal. So if they feel that the judge was required to allow them into the case by law, then they could file a writ.
Right.
So we got three things. Either, we've heard the last of Mr. Baldwin and Rozzi on this. They've done their job, fulfilled their duty, really, to make an accurate and full record to preserve this issue on appeal. And so what could happen if that's what the option is, that they're just going to return to the discovery by the end of the week, which I heard was kind of ordered or discussed. They're going to go back to their practices and do what they do, and presumably the case will continue. It'll be tried, and there'll be a decision, either guilty or not guilty. If it's not guilty, then the case is over forever as far as Mr. Allen's concerned. If he's found guilty, there will be his normal appeal rights. And one of the issues on appeal will be all of this stuff that's been going on the last 2 weeks, whether he had what Attorney Hennessy argued at the end of the hearing per Frank, you haven't done this, you haven't done that, you didn't provide notice, you didn't make fact finding, this finding on gross negligence, there's been no proper finding of that. That will go up on appeal, and if the court agrees that she was in error about that, the case would be reversed and sent back for a new trial. And we went over a case where that happened in 2022. Slightly different issues, but so in that case, the Ramirez case, the lawyer did an excellent job of preserving the issue on appeal of not being granted continuance. He was found guilty, went to the Indiana Court of Appeals. They affirmed the decision, meaning they agreed with the trial court, said the trial court did nothing wrong. They sought a discretionary appeal to the Indiana Supreme Court, and the Indiana Supreme Court said, I like to quote movies a lot, this will not stand. And they reversed it, and I don't know what happened on Mr. Ramirez's case. It either settled with a plea agreement, or it's scheduled or went to another trial. Now, unless there's any questions about that, I'll talk about the motion to disqualify.
Yeah. Well, let's just quickly see. I know we talked about this yesterday, but Jency is asking if you could just reiterate. Did she tell the attorneys to cease working until damage control could be done? Just a thought from that email thread we saw yesterday. So, of course, they're talking about, of course, there's another thing for Docs Pop here. She's talking about, obviously, on the 12th or whatever it was. Remember, she told them to stop working, to cease until the 19th. And if you could just quickly explain again why that had happened.
Well, I don't. Why it happened from the context of the email, which we actually have now, thankfully, everybody has access to, because the RIP that was filed, that was attached. My understanding is no one's ever had an opportunity to see some of these communications that were happening in the background between the judge and the attorneys. But anywho, presumably, the judge at that time had decided that she was going to remove those attorneys from the case, and she didn't want them billing anymore. That's one possibility. The way that's been argued by the defense and in the writ is that the attorneys were prevented from preparing or doing what they needed to do to address whatever issues were going to be raised at that in-chambers meeting at 12:30, and the official hearing was at 2. But, they've argued that, well, you told us to cease work, so we couldn't be prepared to address whatever you were going to, present. Is that what was being asked, and did I cover that, or you think there's some another angle I missed, Sonny?
Oh, that was really it. What you said is that she was, ceasing because, like, the damage, basically, this was getting out of control. A person's life had been lost. Which they're talking about forced in there and stuff like that. And it was just like, I'm hearing a little bit of feedback. Sorry, I'm hearing a little bit of feedback from your phone there. But anyways, so, that was really the gist of it, to be honest with you. Like, a lot of what was talked about was that there was, like, it was just incomprehensible that, this person had lost their life going on these leaks, and it was just like, stop, let's discuss this on October 19th now and get it back under control or whatever. And so, yeah.
So last night I said, I didn't think she had a legal ground to prevent attorneys from re-entering a case as private contract attorneys, pro bono or otherwise. But I disagree with her on that, and that would probably be one of the central issues if they filed a interlocutory appeal or a writ. And I'm not an Indiana lawyer. I could be totally wrong on that. There could be dozens of cases where other judges have done this. They litigated that issue, and the appellate court said no. A court can consider the behavior and conduct of someone who's appointed in determining whether they can come back in as paid counsel. That was very amazing to me.
Right.
But we have a similar thing going on with the motion to disqualify.
Okay, just
so go ahead.
Before you get into that, because you'll do that next. But Hiawatha says, but hers was a different question because there was two people asking a question, but hers was, my question was, he left out without representation from the 12th to the 27th, as far as Gull knew. So basically, when she said to, cease on the 12th or whatever, was Richard Allen without representation then up until the 27th is what her question is.
That's a really, really good question, Hiawatha, because it pertains to a lot of different things that either may have happened in the past or might happen in the future. In the law and criminal case, on issues like constitutional rights, your right to effective counsel, that's the Strickland case. Your right to counsel, that's the Gideon versus Wainwright case. So there's a technical component. Technical is you have to provide attorney for a felony case. And I think clearly he did not have a lawyer for a period of days. And let's go with Hiawatha's date range. I think that's a good representation that he was probably effectively without counsel for that time period. The other thing you have to show a technical violation. He didn't have counsel for a period of time. The other thing that's required is you have to show prejudice, that the defendant was prejudiced by this move. So if a hearing had been scheduled during one of those days and she had Mr. Allen brought and she sought to take some sort of action, and Mr. Allen was there without an attorney, and she said, okay, do you have anything to say on this, Mr. Allen? And he's like, well, I don't have an attorney, and she rules anyway. He could potentially show prejudice with that. But in this number of days that he didn't have an attorney, nothing substantive happened. I don't believe. I don't believe there was any hearings or any rulings other than rulings that only impacted Rozzi's and Baldwin's appearance in the court. So I don't think he can show prejudice, and so no harm, no foul is the way the courts would likely look at that period of time that he was without representation. And this happens frequently, although for completely different reasons. An attorney may become ill or pass away suddenly, and the defendant is without representation for a number of days. And if that happens and there's hearings scheduled, the court will always postpone those until new counsel can be appointed or new counsel can be hired if it was hired counsel, and someone can step in and get up to speed. And matter of fact, I've been contacted by various judges or bar associations, what have you, to do just that, an attorney became disabled or passed away. Could I step in and take over the case? And nothing occurred during the days, or I think one case it was 30 or 40 days before I got contacted to step in the case. And so I didn't have any argument or grounds to complain about the fact that the client was unrepresented for that period of time. I hope that explains that.
Thank you.
I have a question.
Okay.
The Supreme Court, if so with the new attorneys, does everything proceed as normal while things are going on in the Supreme Court? Like, how does anything have to stop until, like, right now we have until November 9th for all to respond to the writ or whatever that was filed with the Supreme Court, but then if they decide to go further, like with the representation and the disqualification and all that stuff, if all of that lands in the Supreme Court, does everything at the trial level continue with the new attorneys? Or does everything have to stop?
Excellent question. And I'm on my phone, don't have video. Was that Cherie?
That's Charmaine.
Charmaine, sorry. And so, Charmaine, that's an excellent question. The answer is no. Nothing is stayed or stopped because of the writ. The writ's going to continue forward. It's a totally separate case filed directly in the Supreme Court, even though the facts surround what's going on in the case, specifically with regard to what the judge or clerk is filing or not filing in the CCS, the clerk's filing, online filing system. So nothing will be stayed, but I'm glad you asked that question because there's actually a fourth possibility. You all heard I said they do nothing. They feel they preserved it, so they're just going to go away, and we're not going to hear anything more from it until, it might be brought up on a direct appeal after a trial if there's a guilty verdict. The second was an interlocutory appeal. The third was a writ. So technically, if they feel strongly that the judge was required to do something today, required, not discretionary, but was required to do something, i.e. allow them in to the case because they were appearing as private counsel, then technically they could amend their writ to include that issue and file a supplemental brief. But we'll just call that part of option 3. But that could happen. And then if that was allowed and the Supreme Court of Indiana said, yeah, we're going to allow that, and we want briefs on that by November such and such a date, conceivably they could say, we're going to stay the proceedings for us to decide that. But writs are decided extremely quickly. And so if that did happen and there was a stay, and these are possibilities that, you know, they're remote, but I'm glad you asked the question. You know, they could say we're staying the case until we determine whether these attorneys, one and or both of them, had to be allowed back into the case. So, you know, I think it's remote, but it is a possibility. And then, of course, the same would apply if they filed a separate writ, didn't seek to amend the one that's pending, but they filed a separate writ. Same thing could happen there.
Thank you for answering me. That's been on my mind even before today.
Yeah.
Well, thanks for the questions, and heard Charmaine commenting about things earlier when I was listening in, and I found everything she had to say to quote a movie, and you know, to be dead on balls accurate. It's an industry term.
That's my cousin Vinny, love it.
Winner, winner, chicken dinner. Okay.
Winner, winner, chicken. Yeah, I used to always say that. Winner, winner, chicken dinner. So you were going to talk about the disqualifying thing.
Right. So that can be filed in any case. If you feel that the judge has said something or done something that you can point to, that shows that they're biased or they're not impartial toward your client, you can file a motion to disqualify. It's called a couple of different things in different states: motion to disqualify, motion to recuse, and there's an automatic form of it in some states where they assign a judge, and let's say you were a political candidate and you ran against that judge. Most states will allow an automatic recusal or disqualification, or you're related. The judge is within the third degree of consanguinity. There's a term everybody can look up. It basically says children, grandkids, they cannot appear before a judge. So there's an automatic form. We're way past that. Then there's a discretionary form. Something pops up during the case that you feel legitimately demonstrates that the judge is impartial or lacks bias, is biased, that, you know, whatever the legal standard is in that state, which they filed. And then that typically is always heard by another judge. And typically the process is that there's usually a regional presiding judge. It goes to that regional presiding judge to assign to a judge to hear that case. In one of the counties I practice in, there's 18 judges who hear nothing but felony level criminal cases. And when a lawyer files a motion to disqualify, they don't assign one of the other 17 judges to hear that, because these judges interact with each other on a daily basis. They just don't like putting judges in a very difficult position. And so they bring an outside judge in. Frequently, it's a retired judge, which they call senior status. They're not going to be running for re-election. They have no dog in the hunt, as we like to say here in the South. And then they hear the evidence, and then they make a ruling. Well, in this particular case, Judge Gohl, to my understanding, ordered those pleadings stricken and removed from the docket and removed from the system. Last time I looked, they were still there and the clerk hadn't removed them, but whatever. So
Yeah, I was going to say they still are there. Yeah.
So that's still sitting out there pending. The new attorneys have an ethical obligation to sit down with their client and say, look, there's a pending motion to disqualify the judge. Do you want to proceed with that, or do you want us to withdraw it if it's still a live pleading, or do you want, if it's not a live pleading, do you want us to refile it? And we'll file it on your behalf. And then it needs to go through the process of being assigned to a independent judge, and that independent judge would make a rule on that. So that's still very much in play.
Travis, just quickly,
Yes.
SB 74 is asking you, can that motion to disqualify be filed by attorneys who have been removed?
No, because that's what the current status is. The new attorneys, so the old attorneys, as of right now, they have no authority to do anything. About the only thing they could possibly file is motion for reconsideration of whatever rulings there were today. And that's a common thing that's sometimes required to perfect something for appeal, to give the trial judge one last shot at correcting any mistakes. And they're frequently just rubber stamp denied quickly. That'd be about the only thing they could file. So if the court, which it appears to be the case, thinks it was correct in striking the motion to disqualify, along with, I think, the notice of continued representation, if the court believes it's correct on that, then what would have to happen is new counsel would have to reassert it on behalf of the defendant, Mr. Allen. Now, there's some ethical things going on here. There's four main things that a client has to consent to, that you have to talk to the client about, and the client is the final decision maker. One example of those four is whether they're going to testify at trial or not. And so everything else under the ethical rules, the ethics, the basic ethics law is that attorneys can decide the strategy and do different things, and it's up to the attorney whether they'll agree to a continuance, whether they'll oppose a continuance. And under normal circumstances, the decision to file a motion to disqualify is ultimately left up to the attorney to decide what's in the best interest of his client. However, this is a unique situation where one set of attorneys felt that there was a bias or impartiality of the trial court. That is a fundamental thing for the defendant. So the ethical rules are going to require them to go in, evaluate it on their own, and confer with Mr. Allen about it. And I think if Mr. Allen was insistent upon that being re-urged, represented to the court, they would be hard pressed not to follow their client's wishes.
Yeah, sorry how I was on mute there. Travis, thank you for that. And I was just going to ask, do you mind if anyone in chat has a question for Travis? He's here, so maybe if there's something that you guys want to ask, feel free to do that. Charmaine, did you have anything else that you wanted to add?
Well, there's been a lot of questions going through chat. See, the last one that I can see is can that motion to disqualify be filed by attorney been removed? So I think you just spoke to that. But
yeah,
what? So the lawyers that filed that writ, they're not regular lawyers. I can't remember exactly what was said about them. I know that they're the force, whatever the force. But can Rosie get them to file this stuff for him?
So this stuff, I think, hear me? I had a call come in that I just hung up on. Okay. So this stuff, meaning the motion to disqualify and the trial court, things in the trial court, no, those three super lawyers that are on the writ, they can't file anything in the that's pending before Judge Gull. The only attorneys who are authorized to file anything on behalf of Mr. Allen are those that are officially in the case. Now, they could seek to associate in, or there's another thing in Indiana law, specially appear. That's what Hennessy did on behalf of Baldwin. He specially appeared solely on the issue of Baldwin's possible removal. So they might be able to specially appear, but when you specially appear, it's on peripheral issues that are intertwined in the case, but are technically separate. For example, Hennessy representing Baldwin was just that, to represent Baldwin on his potential removal. It had nothing directly to do with the issues in the case. For example, he didn't file a special appearance to argue the Frank's motion. And I understand that they're intertwined. Baldwin's client wanted Baldwin and Rosie to stay on, presumably. And so Hennessy representing Baldwin does benefit Mr. Allen, but it's not a direct issue in the case. So those three would not be able to start filing things on behalf of Mr. Allen in the trial court unless they either got permission to associate in or they specially appeared on some very limited issue.
And this order that we're looking at right now from the Supreme Court about November the 9th, that deadline that records must be filed directly by Thursday, November 9th, that speaks to what was in this writ. So, I mean, they go and they file about the disqualification the judge or the reinstatement or the removal or whatever, those are different issues. That's with November 9th, right? Am I correct?
The writ is strictly limited to, and it's real easy if people have access to the writ. You just go to the last page of the argument before the signature lines. I don't know if they labeled it conclusion or not, but last two paragraphs that are numbered, they talk about what they want. And what they want is things to be done with the clerk's file.
You talking about in this one,
And then,
Travis?
pardon?
Are you talking about the brief in support of petition writ? This one?
Yep. Just call it the writ.
The writ.
Don't call it what it's called. That's the writ.
Yeah.
So
Is
the
this what you're
last two
talking
numbered
about?
paragraphs, they talk about what they want. However, there's a proposed order that we went through yesterday and started talking about until we realized it's not a real order. It's a proposed order.
Right.
They talk about some other things that they wanted. And whether those are going to be issues in the writ or not, it's just too soon to tell. But apparently they're going to be trying to seek the relief that they've set forth in their proposed order. And I thought one of those had to do with removal, didn't it?
Sorry, which?
The proposed order. Remember, it had bullet points and we were going through it. And I said, wait a minute.
I think that was
at the bottom. Is this thing signed? And then you all said, no,
Right.
It's not. And I said, okay, that's a proposed order that, has no legal significance.
And the bullet point, I think, just wanted the filing to be reinstated, like not.
Okay.
Because everything was actually moved and then was put back up. But I think that.
Okay. All right. Thank you. I had a lot to process yesterday, but okay. So that's what they're going to be seeking, and those are the only issues. So the options on the writ are the judge and the clerk say, yeah, they're right. No sense in opposing this, getting into it. We'll just send what they call an advisory to the court saying, we concur, this is what we're going to do. This should resolve all the issues. And then there's that fancy legal term, should render the writ moot, because they've done what was being asked in the writ, which was get them back in the system, file the form under the, oh man, my mind, the court access act. There's some form you're required to file if you want to make something private, confidential, not public access. Or another possibility is that the attorney general will be representing the clerk and the judge. They may, they'll contact their clients, the elected clerk and the elected judge, and say, we've reviewed their writ. One, it's total bullshit. We should fight this tooth and nail. Second possibility is it's a well-stated motion. We agree. They're absolutely 100% right. What do you want us to do? You want us to try and resolve this? Or the third option is, some of their stuff's bullshit. Maybe, for example, what Adam brought up, that the attempt to put things on a website is sufficient enough. It meets the spirit of the law. It doesn't need to burden clerk staff to get everything back in the CCS. And, you know, if they think that that they've stated good grounds on some, the AG may say, hey, look, they're willing to do A, B, and C. If they're able to do that, can we come up with an agreed order? Or if they comply with that, will you dismiss the writ? So that may occur, and then that writ would go away. But if they don't feel that they're correct, but I just can't imagine Indiana Supreme Court would think that everything that's been going on with what gets filed doesn't get filed, things that don't get filed, there's no official form stating the reason why it's not being filed or made public. I can't imagine that they would agree that that is all proper and good for, as stated in the writ, the Hoosiers of Indiana.
Parents. Sorry, I keep getting these docs pops going off saying a minute has been added to the entry.
I didn't catch that, Sonny. You saw what?
No, I've like in the last hour it keeps saying that there's an update. A minute entry has been updated. What does that exactly mean? A minute entry?
Okay, great question. So we saw a one-page document last night from the Indiana Supreme Court called an order.
Yeah.
Titled an order. Charmaine was talking about it. They have until November. If anyone wants to oppose, they have until November 9th. They need to comply with these rules. That's something that you'll see in the docket system as an order. And then frequently what you'll see in connection with the hearing, the clerk types notes on what has happened during the hearing. The judge doesn't prepare an official document titled order. She rules from the bench on different things. The clerk is typing those things down, and they're like meeting minutes. That's where the term minute order comes from. And the judge has the option, and it happens in federal court a lot, the minute order, but the judge will follow that up with a written order. But it's quite common where you have clerks in the courtroom that are good at taking notes of what happened. They'll note who appeared. They may note who made arguments, and then most importantly, they'll make notes about what the judge ruled. For example, there may be a note in there that counsel indicated that they will return the discovery by such and such a date. And that's what happened. There's a minute order, but it was post-dated several days on the hearing where the judge came out and announced that the Baldwin had made an oral motion to withdraw, which she granted. Mr. Rozzi is wanted to file something in writing, which he'll submit in a couple of days, and I'll rule on that. And I want to keep the 1031 hearing on schedule. I'm going to appoint a couple of attorneys. You'll see those notes that are written out and that's a minute order.
Yeah, thank you for that, Charles. Because yeah, now that it's almost like I had to like, even though I refreshed the page, but now I can just see there's a lot of of changing, obviously, the dates, hearing schedule, activity, you know, um, just a bunch of different, nothing like you said, not like it's an order, just updatings of the activity that's going
Yeah.
on in the new. Yeah.
Yeah. Yeah.
Okay.
Has,
Yeah. I mean,
has the trial date changed already? Have they updated the trial date?
yeah, I'm pretty sure I just seen that here. The trial date. Let me see here. 15th, 16th, 31st. I thought I seen that. There's so many things here.
It would be at the very, very bottom. It stays at the bottom because that system's chronological. So the very bottom,
Yeah.
it would have jury trial date.
Yeah, they have jury trial scheduled for 11th, which is November. So that one's November 1st, right? So basically, they've put in all the dates from the 15th. So they basically have the 15th. Well, even though this one says the 16th, to the 30 to the 1st of November of
Okay, so
2020.
they've allocated 2 weeks for the trial. That could change, but their system, each court day, calendar day that's not a holiday or a weekend, it'll say jury trial, and there'll be like 10 entries if it's a 2-week trial, 5 entries if it's a 1-week trial, and I don't think it was that many days before, but I could be wrong. But I'm thinking that would be plenty of time, possibly 3 weeks, depending on the number of experts involved. But 2 to 3 weeks would be a sufficient time, because the number of days required to try a case doesn't correlate with the magnitude of the it doesn't correlate to the magnitude of the, I don't want to say sensation, but I can't think of another word. Obviously this is a highly sensational case. There's better terms for it, and it's high profile, clearly.
High profile,
International media attention. It's a big darn case. The way the attorneys expressed it in the writ, they said it probably one of the highest profile cases in Indiana jurisprudence, and they're probably right on that because of the nature of social media and other things. Anywho, so just because it's a super high profile case doesn't mean it's going to take 5 weeks to try or 5 months to try, like the O.J. Simpson case. It just
I remember that one. I remember that one. I took 2 weeks off. I was on vacation back when I was like in my early, like 19 or whatever I was, 20, something like that. Anyways, I took 2 weeks off, and that case had come about, and here I was thinking, it's just gonna, it's gonna only be like that long, and that thing ended up being like, I don't even know, actually, months. I don't even know how long.
I would have bet money you weren't old enough to remember the Simpson case. Oh well, I'm glad I didn't bet.
You talking about O.J. Simpson case? I was like in my 20s.
I would have bet money against that.
Oh,
anyway,
no, I'm 54, right? So, I'm 54.
I would have bet money against that too. Oh well. Okay.
But yeah, I remember those cases. Those are the ones that stick out. and John Bonet's case is another case I would love to see resolved. There's definitely lots of. He thinks you're young. I know, right, Charmaine? I'm still 29, Travis. Just so you know. Yeah.
Okay.
Yeah.
I'll go with that.
Don't let the mask fool you. No, just kidding. But yeah, no, I remember that case very well because I was hoping it was going to be done by the time my vacation was over, but nope. What was I going to say? Oh, I know. What I was going to ask you was, okay, so yes, they've sent this case, and we'll get going here right quick. So yes, they've sent this case back for November of 2024. Now, just in your typical knowledge, what's the chances that that's not going to get still pushed at that, again, in a sense? Is there a high likelihood that it probably will get pushed further, but that's just the kind of date for now?
Well, with it being pushed out a full year, it actually drops the chances that it would be pushed out. The court had previously ruled that the discovery deadline was going to be November 1st. And that's actually a ruling that was very beneficial to Mr. Allen, because what prosecutors frequently do is new information will come in, or sometimes it's old information, and they just dribble that stuff out all the way up until right before trial. And Richard Allen's attorneys had enough of that, and they filed a motion to set a discovery deadline, saying they've just produced discovery as late as last week. And what a discovery deadline is the order says parties have until November 1st to exchange discovery. Any evidence coming after that will be excluded unless the party can show good cause for the late production. And so that's beneficial to Mr. Allen, because all the prosecutors tend to do that, just turn it over when they have a chance to look at it for themselves and send it out. So we need to see, if she imposes, we need to see if that discovery deadline is still in place, number one, and number two, if it's not, if she'll set a new discovery deadline. That also increases the likelihood that the trial will go on schedule. But anything can happen in these cases. A critical witness for the defense or a critical witness for the state isn't available, so on and so forth. But Indiana allows depositions of witnesses, so the chances for that happening are slim, because either side can take depositions of any witness in the case. The depositions don't get filed with the court. They're not produced until the time of trial and a witness is unavailable. Then they'll read the transcript in. So why don't we have the transcripts? Because they're not typically filed, and I suspect Indiana's open records law, whatever it's called, doesn't allow anybody to obtain depositions as an open record until the case is concluded, or it may be never. But in any event, we know many depositions have occurred, and but it being pushed out a full year, I would say there's a 90% chance it's going to go, because it's not like she reset it. I'm going to continue it till February. Some judges will set a trial date that they know is impossible, just to keep the state and the defense working on it. And, they'll, we're waiting for this test results. We're waiting for that. And the judge continues, I'll continue it another month. But here, I think the judge is taking a realistic view of how long it's going to take for 2 brand new attorneys to get up to speed, comply with their ethical obligations to do their own investigation, their own analysis. And I can't think of a reason why that would not be possible for that to happen. And so by putting it out a year, greatly increases the chance this thing's going to go when it's supposed to go. If she'd set it for 4 months, it would reverse. I'd say there's a 80%, 90% chance they would seek a continuance, and she would certainly have to grant that. And she's learned from that, because she got reversed in Ramirez based on that.
Right.
So, so if people are upset on the delay, they shouldn't be, because that's, in my view, going to be a fairly firm date. And so you can count on it. I know it's disappointing that for a lot of people that they thought they would have the answers they've been searching for in January, but this thing came up.
I meant to ask you this yesterday. What about the in-chambers transcript, Travis? Will that, or should that be a public record, do you think?
It should be. That's why they kept filing precipice for transcript. And I'm sure that the media and others are going to be dogging that. Now, something that was concerning as part of the order for today's hearing, she had previously denied media outlet requests for cameras in the courtroom for this hearing, but denied it and had a little dicta in there because the court's order was violated regarding showing pre-hearing video, or and not sure exactly what that was about, or if y'all even figured out what that was. But
we already know what that was about. Yeah.
What?
We know what that was about.
Okay. So they denied cameras, but she listed a lot of things. She obviously prepared that in conjunction with court security staff about, who was going to be screened, how they were going to be screened, where they could sit in the courtroom, et cetera, et cetera, et cetera. But one of the things that really intrigued me, and I went through that entire lengthy minute order in the file system. She said there will be no public transcript or recording available of today's hearing to the public or the media. And I've just never, ever seen that before. Now, that may get added to the writ, and she may actually fill out the form that she's required, that I made that order in anticipation that sensitive materials might be discussed during the hearing. They were not discussed during the hearing, therefore I'm lifting that order and it's now public. But going back to the in-chambers, she didn't issue any kind of order like that. And if the court reporter is recording the conversation, it's considered on the record, and either side should be able to request that transcript. It's been requested as part of some motions. I think she'd be hard pressed to not provide it to the lawyers. And in my view, if the lawyers are entitled to it, then the media and the public are entitled to it.
Yeah.
But she's done some things that are clearly outside the norm. And if the writ's correct, in violation of some Indiana law and public access to court rules.
Right. Guess we'll have to wait and see, eh? Travis? Hello? Travis, can you hear me?
Oh, yeah, loud and clear.
Oh, okay. Okay, yeah. I mean, I was going to say, I mean, at the end of the day, I guess we're just going to have to wait and see how it all plays out. See what motions are filed, see if there was any, I guess, wrongdoings on Francis Gold's part or whatever. I don't know. But I appreciate you trying to, or explaining it to us, kind of what's going on. Do you think that the new lawyers will adopt, what was it? In that filing, the continuancy one, do you think that the new lawyers will adopt the whole odinistic line, do you figure? Or do you think that they'll just basically start
that
fresh?
motion for sure is pending. That's a great question. And I know it stirred up a lot of controversy among the community, I'll call it, that are both, regardless of which side of the fence they're on, it stirred up a lot of controversy and about the lawyers and, other things, outrage at the prison warden and correctional officer, just controversial subject. But that motion for sure is pending. After the hearing a couple of weeks ago, she put in her post-dated order, wasn't filed until after Rozzi filed his notice of continuing representation and motion to disqualify. She filed an order dated the date of the hearing, but after the fact, post-dated. So she said in there that there are motions to suppress that are pending, that this was discussed in the chambers, that presumably was recorded. She said, there are several motions to suppress that are pending.
Yeah.
I'm going to wait ruling on those until I decide the Franks motion. She said, I'm going through the Franks motion, but there's, 1,000 pages of exhibits and multiple hours of electronic media. I'm going to continue to review the motion, and she wouldn't rule on it after her review. What she's going to rule on is whether she'll either deny the motion and say they're not entitled to a evidentiary hearing, or she'll grant the motion to the extent that you've laid out enough here that it justifies an evidentiary hearing on these issues, and therefore you can call witnesses to the hearing that will testify on those issues. And she may carve some of the things out and say, you know, there's no merit to this, there's no merit to that, but you've laid out something that potentially could have merit. So that's a pending motion.
Yeah.
I have a question.
She's got to proceed forward with that unless the new attorneys advise her, we wish
Right.
to withdraw that.
Yeah.
And new attorneys would be hard pressed to say, we want you to withdraw that, because other attorneys have filed that on behalf of Richard Allen and state that they have a good faith basis for it. The court has never said that the motion appears to be in bad faith or is meritless or frivolous. Those are the buzzwords you hear. And so for them to go in and yank a pending motion, it's the same with the motion to disqualify. And they would have to talk with Mr. Allen about why they think it would be in his best interest to withdraw that motion. And if I was a new counsel coming in on a case and I saw something that I felt just really wasn't in my client's best interest, it would be detrimental to him. And, you know, I would sit down with him and say, okay, look, this is what my view is, and this is why I think this motion prepared by your previous counsel is going to do more harm than good. I understand where they were going, but this is what I think. Here's the pros and cons. Technically, it's ultimately my decision, but I'm going to give a great weight to your input. And then they would say, no, I want to continue with it. Or I agree with you, I want to pull it. I would follow that up in writing with the client and say, we've discussed this. Here was my view. My advice was to do X, and you agreed. If this is correct, please sign this letter and return to me. Or your decision was to not follow my advice and have me continue with the motion that's already been filed, which I will argue to the best of my ability on your behalf, even though I disagree with the overall decision. If this is correct, please sign this letter and return. And then it's clear, because believe it or not, if you have a trial and it doesn't go the way your client expects it to, people's recollection of the events change dramatically. My attorney never conveyed a plea offer from the state, or my client, my attorney told me, I couldn't testify, or whatever it might be. But you would confirm the thing on the motion to disqualify, and you'd confirm the issue on the pending motions to suppress and the Frank's hearing. And I'm really glad you brought that up, because that's going to be on the forefront, regardless of what happens with the motion to disqualify, regardless of what happens with the writ. Those are pending motions. The judge has acknowledged she's going through the Frank's motion. And once she decides that, she's going to get to the other motions to suppress. Those motions are critical and vital to the defense. They may have less than a 1% chance of being won, but they preserve issues for appeal. And so they have to be brought and they have to be ruled on, or or you waive that. And so those things need to be decided. So that's what they're going to be gearing up. And I would suspect she's going to be communicating that to those attorneys in one way, one form or another. You know, the first thing we need to start to handle is these pending motions. I want to know how long it's going to take you to get up to speed to be ready to argue them, or determine which ones you want to keep, which ones, if any, you want to abandon, or if there's any others that weren't filed that you think should have been filed. That's going to be the new focus. So that's what, you know, I think the community, your audience, your viewers, subscribers, that's what they should be anticipating for certain in the near term.
Yeah. Charmaine had a question for you.
Actually, I was thinking if the new attorneys could withdraw that Frank's motion, but you answered that.
Yeah.
But what I'm thinking is, I mean, if I was the new defense coming into this case, I wouldn't give any thought into anything the old defense said. I would want to review everything and come to my own conclusions and then deal with stuff. But I still would think it would be a good idea for them to withdraw that Frank's memorandum or that Frank's motion, and then maybe refile it without all of the drama in it. Though you talked a little bit about the Stoddard defense last night, where they can actually name names and point fingers of guilt somewhere else if that's their intended defense, but it should have been redacted, and maybe the Frank's issues should have been first in that memorandum, and then the other stuff towards the back, so that it wasn't so muddy. You know what I mean?
Yeah, and to be honest, that I told Sunny this when she first contacted me over the weekend about maybe coming on and answering some questions. I started saying, yeah, this is what I proposed to do, and it was to talk about these previous motions. And then while preparing for that over the weekend, the writ dropped on Monday, and I said, well, forget that, let's go with the new stuff. And then I put a thing in there. I said, I'm going to tell you up front, I'm only 30 pages into the Frank's motion. I quit reading it when these new things started happening with removal and all of that. And I wouldn't be prepared to talk about it, but I know very little about it.
Throughout that entire thing. I mean, it is, but it's in spots and it's not very well organized. You know what I mean? So if I was in the defense, I would pull that old one back and do it in a way that points out the Frank's issues instead of the.
Basically, they told the whole storyline, and
yeah, just kind of placed Frank's issues within that entire 136 pages throughout, but it wasn't organized enough for anybody to take them seriously because everybody was all focused on insanity of the Odinism and stuff.
Yeah, and of course, as a defense lawyer, like being a football coach, sorry to use a sports analogy, I hate doing it, but
it's fine.
they say, never let the crowd decide if you should go for it on fourth down. His defense attorneys, and I feel fairly confident in this, that they're not going to give any weight whatsoever to what outsiders, the public, the media, think about any particular motion, either something filed by previous counsel or by them. I think they do need to do exactly what you're talking about. They need to independently evaluate it. And so they have a few different options after they review it. They can leave it as is and say, Judge, we want you to keep proceeding forward and we want a ruling on it. After conferring with our client, they could say, Judge, we want to withdraw that motion after conferring with our client. Or, excuse me, what I think the most likely thing would be is, Judge, we want to file an amended motion. Rather than pulling it completely, they would amend it to clean it up, organize it, maybe withdraw some issues, maybe assert some different issues. But the best way would be an amended pleading, or you could do maybe a supplemental pleading. But if you think there's some merit to it, you don't want to totally withdraw it. You want to get permission to amend it, which I'm sure the court would be more than happy to allow.
Can I just say too, and just tell me if I'm wrong, that there's a lot of things that are a matter of perception, but a Frank's issue, it either is or it is. Am I wrong in thinking that way? Is an issue or it's not a defense is perceiving something when it comes to Frank's motion. Am I out to lunch?
I kind of caught every other word, and I think I know where you're going, but can you state the basic premise that you want me to comment on, whether you're right or wrong about?
Just if, when you're thinking about a Frank's motion and the Frank's motion issues that they outlined in the memorandum, I don't think those issues are a matter of perception for the defense. Well, I perceive that Tony Liggett not stating this or changing that is not a matter of perception. He either did that or he didn't that. Like Frank's issues they're either there or they're not. It's not a matter of perception. Does that make sense?
Yeah, and generally you're absolutely right. Generally, a Frank's motion, and I like people to be fully informed, and I like to go back to the basics. It's called the Frank's motion because the case that determined it in the United States Supreme Court is Delaware v. Franks. And basically, when you're attacking something that's been obtained by a search warrant, you're limited to the affidavit that has to be filed with the request for the search warrant, where the law enforcement officer lays out things that he has personal knowledge of or he's been advised of by other law enforcement that he knows to be reliable. And you lay it out and you state the grounds. The car was weaving, it ran a stop sign, pulled it over, person made furtive movements, which is fancy for trying to conceal stuff, moving his arms around, can't see what he's going for or hiding, odor of marijuana, whatever. And if you believe you can show to the court that the law enforcement official who signed the affidavit in support of the search warrant lied about things in the affidavit, that for example, there's a in-car video, he clearly came to a complete stop with his car. You'd be able to go in, call the officer, and say, you were mistaken, or, you lied about that, whichever way, it doesn't really matter, but you were mistaken. He clearly came to a complete stop. And that was a basis for stopping and ultimately searching the car. Isn't that right? Yeah. So what the court then needs to do on anything that the defendant establishes is not true in that affidavit, they have to strike that out, line it out, reread the affidavit and say, if the other material that's left were not lies, is that enough for the stop? Is that enough for the search? And if it is, the stuff doesn't get suppressed. If it's not enough for for the search warrant, then those items get suppressed unless there's some other exception that applies. So, but in this case, they're not arguing the traditional Frank's motion. They lied about this stuff. What they're arguing is that they didn't include information about other possibilities. And so the overall effect of the affidavit in support of search warrant is misleading. And that is a possibility. It's very, very rare. It's a much tougher standard to show that what they didn't include is misleading to the point where the other information would have led a reasonable magistrate to conclude, knowing this other information, I never would have signed that warrant. That's a very tough thing to do. But you're absolutely correct, Charmaine. In the first instance, it's not perception whether the officer lied about the car running the stop sign if there's video evidence. It's the judge looks at the video and says, that's not true. And then goes on with the analysis from there. If you take that out of the PC affidavit in support of the search warrant, is there enough for the search warrant to have been issued? But when the issue is whether leaving out information, because there's no obligation in a search warrant affidavit, there's no obligation by the state law enforcement to include everything. There's no requirement to put the pro and the con, if you will, the good and the bad. They can just put in facts that support the search warrant. And they have to be truthful about it, but they don't have to include the stuff that's exculpatory.
Of course.
That comes later. But if it's an issue, which is rare, again, where it's a matter of what they left out makes the entire affidavit misleading, you're right. It's not so much a matter of perception, but it becomes more of a subjective analysis versus an objective analysis. So first case, it's objective when you have video and there's no, it's clear that the car came to a complete stop. There's no running of the stop sign. That's objective. It's not true. I'm going to line that out. In theory, what's left is also subjected to an objective analysis by the court, and they determine if there's still enough for the warrant or not enough, and they suppress. But when you're looking at, here's this bundle of facts over here. First, you got to decide, okay, is this stuff really relevant to the issue I'm trying to decide? Whether this, because you're only allowed to look normally within the four corners of the affidavit, not allowed to go outside of it normally. But, so they're looking, would these bundle of facts over here that weren't included be significant to a magistrate in determining whether to issue the warrant or not? That transforms more to a subjective analysis. Kind of gets in those gray areas. So perception, it could be phrased that way, but it's really, you're analyzing it different than a normal straight Frank's hearing. And when you see people talk about Frank's and this is what the judge is going to do, they're really not talking about this situation, which is very unique and very, very rare. And so when people comment, yeah, Frank's going to determine if it's true or not, none of that applies. There's a few cases that say a judge can look at, in a very specific situation, that if complete facts have been presented, it might have impacted the judge's decision on whether there was probable cause to issue the warrant. Perception is to me a term that's even more subjective than I think what the court's going to look at. But no, you're totally correct. In the normal Frank's hearing situation, perception doesn't come into it. It's I listen to the witness. If there's video, great. If not, I evaluate the credibility of the officer. Through questioning by defense counsel, they're able to establish what he put in the affidavit cannot be true. I need to strike that out. I move on. In this situation, though, it's defense is saying if this other information had been included, which it's clear, they're going to be presenting documents where that stuff was included, either through deposition transcripts of that one detective who was retired, other things. They're going to have to look and determine if this information had been known to the magistrate. One, does it make what was submitted misleading? And if it was it so misleading by not including this information that no reasonable magistrate would have signed it? Some people might call that perception. I don't. I call it an analysis that gets more subjective than in the normal case. Did I answer your question? Sorry to go on so long, but those are key principles.
Yeah, with the whole, the whole memorandum there. First of all, that's what's caused all this stuff, to be honest with you. It was because, kind of like what the defense, the prosecutor said, right? Like it's basically 13 pages out of the 136. Really, when you read it, to me, it's like a story, and the defense is perceiving Richard Allen's, a person's movement that's not Richard Allen's, kind of given the step by step. They weren't there. They don't know exactly what happened. And when you look at a picture, right? Like, let's say you're looking at those crime scene photos or whatever, the prosecuting attorneys aren't going to, you'll obviously go along the whole Odinism line and look at the picture. Now, they tried to, for instance, take the crime scene photos and make those sticks by their own perception and what their storyline is, make it seem like those are ruins. But when would you see this whole, for me, let me just put it this way. it was clear to me that the defense was trying to get out to the public their whole Odinism line of, like to move it out to the public so that the public could see, well, this is what the crime scene looked like. This is what was on them, these sticks that look like runes. I mean, they didn't even get their facts straight with what the runes actually stood for, even if they were correct, because they called it Hail Odin, even though the F didn't even look like an Odin symbol and stuff like that. And that's where, for me, it's all like the perception. So they're putting out their perception of what these crime scene photos, seem to dictate. But at the end of the day, should any of that stuff really been in the Frank's motion? Because isn't it about facts, like you said? Like, if there's a video of a car that's clearly stopped and the police officer said, no, sorry, you went right through that light, you weren't stopped or whatever. So, like, I know you only read 30 pages of it, but like literally most of it is them talking about the crime scene and then doing this play-by-play step of how something would have transpired. But the thing is that they don't really know that, to be honest. I don't even think that the freaking LE knows that about exactly what happened to Abby and Libby. And it's like someone putting their twist and the spin on it to project that, with all those little side notes in there as well. I don't know, but should any of that stuff even really have been in there? Because to me, it was just the defense's way of propagating their Odinism line, getting it out to the public, and letting us know. And I think it was Travis here says, do you think the Frank's memorandum further revealed discovery? But I know you haven't read it all, but that was the big gist of it. Like, why is all this crap in there about Odinism? Isn't this for a Frank's hearing? And why are you laying out this entire story?
Okay, so a couple of things. So if that's what Charmaine meant by perception, the perception of the lawyers in arguing why they believe things are untrue. Attorneys on either side in closing argument, in briefs, are allowed to argue what they think the evidence means. They're able to argue that to a jury. We think these dots, A, B, C, and D, allow you to conclude this. Neither attorney knows. The state doesn't know. They weren't there. The defense doesn't know. So they're not allowed. It's a form of perception, but attorneys in general are allowed to argue to the court what they think certain facts mean. Because it's rare. You don't normally have a video except in a traffic stop. And then only recently, where most cars have dash cams that activate automatically and record a minute before the overhead lights come on. So it should capture the violation. It's very rare, but I'm just giving hopefully clear examples. But so it's a form of perception that the attorneys are saying, there's these facts, and we think what this means is that in this specific situation, that the affidavit is misleading. It's not lying, because, we don't have that. It's not a typical Frank's thing, but overall, it's misleading to the point where a reasonable magistrate wouldn't have issued the warrant. So they're allowed to argue facts. I can't comment on this case specifically because I haven't gone into it, but here's the rub. And here's the problem with, for whatever reason, doing what she's doing with the motions. So the motion was originally filed, and then it got, somebody laid this out for me. It got sealed, then it got released but redacted.
You're
then
talking about the
full
Frank's
thing.
motion, right? Yeah.
Yeah. Tell me the history of
Well,
what was public, not public, or the exhibits public.
well, the
Take
thing
me
with
through that.
I mean, with the Frank's motion, it was released, and it was released with all the names, everything. Okay, it didn't have crime scene photos or anything like that, right? It was simply the like I said, this whole storyline of Odinism throughout it. But it was released, and then it was and then it was closed, and then it was redacted, and then I believe and then I think it was just literally taken off. I believe people said, and they couldn't seem to find it, but I don't know about that to be true or not. All I know is I first and foremost don't understand how they could. I don't know, at this part where I don't understand, how are you able to release the people's names on it and make it public, considering that there's this I don't know, gag order on it, but to let us know of all this discovery, in a sense, do you think that we should have had knowledge of the crime scene and how the bodies were laid, and and different things like that, or do you think that was I don't know, I just, from my point of view, I just feel like that was so wrong that they gave you a visual of the exact crime scene, but yet we had no clue as public that was even the case. We didn't actually know up until this uh, uh, Frank's motion came out. But anyway, so that's kind of what happened with the Franks, is that it was, put out unredacted, then it was redacted. Then people said you couldn't find it, and then they seemed to take it down or whatever. I don't know. I can still find it online.
And then from what I understand, that explains, why I could see there'd be outrage about it from a majority of the community, or at least a significant segment. Okay, but I'm also to understand that the thousands of pages of exhibits and media files were never accessible to the public. Is that right?
Up until the Greenlee and that filed the motion to release information. Other than that, everything was confidential up until pretty much that point. But nothing was ever released about the crime scene.
No, I'm talking about the thousands of pages that the judge referenced herself that she's going through, because we know the motion's only 136 or whatever, but she references in her minute order, I'm still going through the thousands of pages of exhibits and the hours of electronic media, which is videos or audio. I'm assuming that never got released. I mean, you'd know if there was thousands of pages of exhibits.
Well, the thing is that, I mean, obviously there's stuff that's not been released that we haven't seen, but I'm not sure what that 1,000 all encompasses, because obviously, like I said, that, the things I'm talking about. Remember the exhibits on, what was the exhibits on the 240 pages or whatever, where they were showing those exhibits and stuff like that.
But
so,
none of that stuff would have been exhibits
part of it.
To the now they attached the whole unredacted motion. I noticed that that was kind of a jab to the judge in the ribs. Should have just complied with the law to begin with. Here we are. Anyway, so here's the answer to your questions.
Yeah.
So there's no way for any of us to be able to properly judge the propriety of the arguments, not even the propriety so much, first the propriety. Is it proper to argue that in the motion? But the logic of it, whether they make sense, whether the merit of their arguments, there's no possible way to judge what they're arguing without having all of the supporting exhibits and videos and audio to do that. And therein lies the rub. Some states like Florida, and they call it a sunshine law, and everybody remembers the case kind of led to Nancy Grace's downfall. But in what was her name, the defendant and her little girl, Jose Baez represented her, the defendant, and you all know this case. What is it?
I'm not sure actually which one you're talking about myself. If I hear it, I might know. But
Tot Mom, huge case in Florida.
Casey Anthony.
What?
Oh, Casey Anthony. Yeah. Okay.
So in Florida, everything's available. It's the Wild West. It's freewheeling. The police report was public. That's very rare. Most states, not while the case is pending. Sorry.
Okay.
Hang on.
Yeah.
I think everything, but I recall Nancy Grace showing photos, not real bad ones, but I recall her showing crime scene photos. I think she showed photos of that tape that were presumably, and they grayed out. They used their discretion to gray out like the skull and whatnot. But Florida is at one end of the spectrum. And, Nancy Grace, was able to comment and provide her opinion about, the defense and everything about it. And then you have some states where the pleadings are public, but everything else is locked. David and the and whatever gets filed. And then if a gag order is in place, normally the gag order doesn't apply to what's filed. What attached the gag order might apply to, and so they'll file exhibits under seal and let the court determine what should be opened up to the public or not. But there's the rub. If the court is on its own saying, I'm going to unfile this, and there's 100 and some odd motions that aren't public, that's the meat of what the writ that got filed about. They've said, look, if it's fine if a judge wants to determine that a pleading shouldn't be public, but we have a process in Indiana. You have to file the specific form and state the grounds why it's not public. Then the public can look at it, or the media, and say, that's bullshit. That's not an exception for this. It can't be. And then you file you have a hearing about it. But she skipped all of that, so we don't know. And and that was one of the big things in the writ, is at one time she had determined that she could decide which motions were public or not, and I believe one was the Frank's motion. And then they pointed out you can't determine that an entire pleading is confidential. You have to redact certain portions of it and leave the portions that aren't confidential. In other words, you got to put a little work into it. You can't just say, oh, there's some stuff in here, it's sensitive, the whole thing's confidential. And as a matter of fact, either intentionally or unintentionally, they give a little jab to the judge and point it out in the writ. The gag order does not apply. It applies to extrajudicial statements. That means the lawyers, in this case, it applied to the family, others, court staff, can't talk about this case in public, anything about it. Can't talk to the media. But it did not apply to filings with the court. And what did they do? They attached a full unredacted copy of the motion as an exhibit to show the court this is an example of the stuff she's disregarding Indiana law about and determining as confidential. And so stuff like crime scene photos, there's no question, everybody would agree, that doesn't need to be public. But it's absolutely going to be necessary if you're trying to show that the crime scene is suggest, or a stronger word, suggests a ritualistic murder and a particular sect or religion. You would need that, so you would put them in there. Now,
So
there's
you
many
think that
different ways.
Travis, so just quickly, so because a lot of people have been very upset with that Frank's memorandum. So just to clear it up, within that Frank's memorandum, I know you only saw 30, like the read 30 pages. So are you saying though that basically like that stuff was appropriate to be in the Frank's?
Sonny, I can't comment because I haven't read it, and I don't want people to misinterpret what I'm saying. But there has to be a means. What I'm saying is if the judge followed the law, as I understand from the writ, if she'd have followed that, there would have been no problem. But she doesn't follow it. She just says, this is confidential. And then the parties agreed amongst themselves that they could agree to designate certain exhibits or motions confidential, but the rules say, attorneys can't even do that, and that happens frequently in family law cases. The attorneys get together and say, okay, well, these medical records of the kids, that's confidential, this, that's not going to be filed. And, they'll do that. But in Indiana, the right for the public and the media to have access to documents trumps. And I'm sorry if lawyer descriptions, the lawyers have to be able to say what those photos mean, what to them, in their view, their perception. They have to be able to argue that, hey, our experts looked at it, or hey, we took a deposition of the detective who's retired. This is what he concluded, that this particular thing in this photograph means, and there are ways, and if it was me, none of them would have either victim in the photos. We would, there's ways to work around that, but I have to be able to argue to the court that, and let's just say it's not Frank's. Let's say it's about why I need money for an expert in Odinism. And I would have an affidavit from my expert saying I've done a brief review. What I've seen here, suggests or is clearly indicative of Odinism. Here's why. Here's my credentials. Here's my background. Here's my expertise. And you have to be able to argue that. And unfortunately, and I don't know, don't shoot the messenger, but our system is such that even if that is painful for people, that the right of the defendant to a full and fair defense, and our system that trials and pretrial hearings be public, the fact that things written in briefs might be upsetting to the family or others is a secondary consideration. And if it's such that, if the court thinks it's just gratuitous, meaning this stuff's added in for no reason whatsoever, the state can file a motion that says just that. This stuff is scandalous, impertinent, and should be stricken. And then the court would decide. There's mechanisms for this. We just don't automatically say, oh, this is going to be pain. A clerk reads it and go, oh boy, if I was family, this would be painful. I'm sorry that our system doesn't work that way in any state. And in fact, in some states, it's like Florida, it's the exact opposite. You write anything you want, attach any photos you want, and the media can get their hands all over it. And it's a violation of law to try and hide it under the Sunshine Law. And people that followed that case was on every night on Nancy Grace. They'll remember the photos and things that were shown. I think they did a good job of, limiting what was depicted. But I mean, those photos were raw, and maybe this is the first case people have followed, and so they think this is kind of the way it works everywhere. It's not. That's what that writ's about, that what the judge is doing is wrong and improper. Now, of course, the Indiana Supreme Court, after they get briefs, if they get briefs, they'll be the ultimate arbiter of that. But, and they may even say, look, we don't agree that these things should have to be included. We don't agree that you should have to file these forms on something so horrific. But that's for the legislature to decide, not us. Elected officials are really good at shifting blame. You'll see. And so, it's, again, don't shoot the messenger, but one thing's for certain is, and again, I don't know the specifics of the Franks motion, and I'll never know unless I have all the exhibits, all the audio, and all the photos, and all the videos. No one ever will. Whether stuff's put in there gratuitously for no reason other than to stir things up, or whether it does have some bearing on the court deciding whether Odinism, one, is relevant, number two, whether Odinism should have been included in the PC affidavit in order for it for a magistrate to determine. Those are the ultimate issues. But I think that's part of the thing, that maybe people these issues don't come up. I don't remember any of this stuff coming up in Murda, and I know that there was horrific crime scene photos. I remember part of the trial. I didn't watch much of it, but when they put stuff up on the screen, they would put there's monitors on each counsel table. When an exhibit comes up, there's a monitor for the judge to look at. There's crime scene photo of the witness to look at, and then each counsel table. And they would put up their legal pads in front of the monitors so that the gallery, the observers and the audience could not see them. Particularly the family couldn't see the photos of his wife and son. But, you know, I'm sure in Georgia or wherever the hell that was, they, you know, do not allow crime scene photos to be released. There's probably a specific statute. Most states have a statute on crime scene photos and coroner reports. It doesn't come in, but I'm sure if there were issues related to those photos that required the attorneys to describe in part for the judge what it is they have an objection about, they would do it. But, you know, typically the way we do that is it's done in a pretrial hearing, and, you know, we print out hard copies of the photos, and we try and reach an agreement with the state on, okay, you know, what are you going to use, and get them to narrow it down. And then, you know, then anything we can't agree on, then we go to the judge and say, we object to this one because it's unnecessary for these reasons. Anyway, so the short answer to your question is, I just can't say, but part of the problem is twofold. If you agree with the attorneys that filed the writ, part of the problem has been the way the judge has been conducting things regarding the filing of motions and sealing them, determining they're confidential. And part of the problem clearly could be the way that defense counsel went about it. And then whether that justifies their removal, you know, that issue's now moot unless it comes up in an interlocutory appeal. It comes up for appeal after a guilty verdict, or the writ's amended or a new writ's filed. But, you know, I think that's the fairest and best explanation I can give it, is that all I can tell you is the way things that have been running on how motions are treated and whatnot that's just not how it's done. And unfortunately, I mean, I see things on motions now that attorneys will put a warning, like what do you call it? A trigger warning almost, you know, please be advised this has sensitive information in it. But unfortunately, people commit acts that are going to be difficult for family members and even non-family members, the general public, to read. But last thing I'll point out on this, it's an interesting dynamic, and I'd love to hear yours and Charmaine's view on this. The true crime genre and true crime fan, from what I've observed, you know, there's a significant segment that not necessarily the blood and the gore is what appeals them to the genre, but, you know, the crimes that get all the attention, you know, involve children or typically murder, heinous stuff, and or the other one is someone's having an affair and the spouse gets killed. Those are always big. But, you know, That's what gets the numbers. And so some of this stuff, I hear people arguing out of both sides of their mouth that this stuff should be public. The motion to unseal that stuff was filed by a content creator. It's public knowledge, murder sheet. Why? Because they want to look at that stuff and determine and, put out what they want to put out. Let's not kid ourselves. Your ability to do what you do and other content creators on YouTube depends on, to some extent, the number of folks you have, subscribers, and all those different things that I'm not specifically aware of. But there, there's a, for lack of a better term, there's a market for this stuff, and it's huge. Yeah. I didn't even know there was a crime con or whatever it's called. I mean,
yeah, crime con. Yeah.
Now, I don't think you or anybody else is making huge bucks off this. I sincerely believe you are doing what you're doing for altruistic reasons. People don't know what that word means. It means good intentions, perfectly good. I have no doubt about that whatsoever. But the market, it's human nature to be intrigued by these types of cases. And so, I'd like to hear yours and Charmaine's comments about that on the one hand, maybe your subscribers were way turned off about that, but yet that's what draws them to the case. And maybe I know you guys can educate me a little bit about that, and I can get a drink of water.
Yeah, absolutely. Hey, Charmaine, do you want to answer that first?
Well, speaking as somebody who's a more recent, I guess, content creator, if you can call my podcast content, before that, I was interested in true crime, like I said before, because of my brother. But mostly, like these cases, it's because it happened. We, as human beings, we relate things to our own lives. And so when I'm thinking of Becky, Patty, and Carrie, and Anna, I'm putting myself in their shoes, and there, by the grace of God, go I. And so now I'm invested in this case because it pulls at your heartstrings. And that's why I think a lot of the public becomes engaged in it. And then you've got the content creators that are putting the stuff out, and even conspiracy theories and things that make it more juicy and more interesting. I think that really catches. And unfortunately, there are some YouTubers that are in it for the clicks, and will put whatever clickbait headline they can up there to get the most views. And they put out stuff that is absolutely false, not true, and they completely make stuff up. And those are the people who give everybody else a bad name. But just as a citizen, like as a lay person, as a mom, as somebody just interested in true crime, that's why we're interested in it for a certain reason. But then it becomes relatable, and oh my God, that doesn't happen to me, my kids. You know what I mean? That's what keeps our interest. And then it's the YouTubers and the podcasters and everybody else that come in and just kind of create the atmosphere to bring everybody in, and then it just goes from there.
Yeah. Me and Charmaine are really on the same page, to be honest with you. There's really what I would consider disgusting YouTubers out there, but those are going to be in like a lot of the different communities. For us, and like Charmaine, you're in it for the right reason, as a caring heart, as a mother, as just a person that just cares about people. And so, like I didn't intend myself on ever being in true crime. In fact, Travis, I literally, from when I was 26 years old, I stopped reading the newspaper and anything to do with death, because every day it just seemed like no matter if you turned on the news, read a newspaper, it was just about, these tragic events. And for me being like a deep empath, and I know that Charmaine is as well, it breaks your heart. Like I literally feel like I'm living through their emotions. And so I never even touched anything up until one day I was on YouTube, and on the right hand side was the Delphi case. And I literally sat there and told myself, do not click, because I just wasn't in to the, like, not, I don't want to say I wasn't into. It hurts my heart too much to know that people are suffering at the hands of these murderers, these killers, these whatever, pedos, all these different people that you don't even realize to the capacity that it happens. And so it was during the Suzanne Morphew case, because that case kind of came out as well while I was looking at the Delphi case, not in any intent of being, I wasn't at this point a YouTuber or did true crime. I was just watching the case, but it was Suzanne Morphew's case that propelled me to bring it up, because I didn't want people to forget Suzanne and the case, because everyone seemed to be very disheartened when there was a search that happened in her case, and that nothing became of it really from that search. But I just from a caring point of view of just wanting justice for Suzanne, I just wanted to keep her case in awareness, and that happens, like I said, with a lot of these cases. Now, like Charmaine said, sadly, that, there's these really shitty YouTubers out there that literally live off of clicks and views. And for the most part, the reason why is because most people are into conspiracies, and they want to hear this false, juicy stuff that they're propagating out there, because they're playing off everything off these people. It's like brainwashing. And these people just keep going to these channels, to me, to sit there and listen to a bunch of crap. And I refuse to be like, meaning, yes, we make mistakes and say things that maybe are inaccurate, but we'll, I'll always come back and recorrect it if I was wrong on something and stuff like that. But the bottom of the line of this channel, and like some really good ones, is that they're putting out the information, of what's going on in the true crime with different cases and different, obviously creators, like, thank goodness for that, because some people talk a lot about the McCann case. Some people talk a lot about, John Benet Ramsey case and stuff like that. So there is a big community that is on the growth for sure. But it would just really be nice, and this isn't going to happen, is if, like, people did it from, of course, their heart first and foremost, over the money aspect of it. And that's what saddens me. It's not going to change. But that's what makes it sad, because then you have all these people, like I said, that start believing this crap. Like, I don't know how many times with the Brian Kohlberger case, I have to tell these people, do you understand that audio is not real? It's not from the Kohlberger house. And then you tell a creator, like, look, here's proof. They don't care. They're still going to sit there and make a live about it, because they're going to get the clicks and views off it. So it's just one of those things. For me, I like to think, and I don't care what anybody else thinks about this, I do things more, what I deem to myself as morally responsible, morally correct. And the bottom line is, it's about caring about people. Do I make a shitload off this channel? Absolutely freaking not. I basically, if I'm lucky, make 500 to 700 at best, maybe 1,000 a month, compared to my $3,400 job. But the thing is that my husband is supporting me as I do this, because as much as I didn't want to be in true crime for the sadness of what happens to people, by the same token.
Yeah, and again, I'm sincere when I say I know what I describe for sure doesn't include the reasons why people like you and Charmaine are doing it. I knew that. I was just talking about in
Yeah.
general, and present company excluded. But you brought up something that reminded me, when cases like this end up unsolved for a while, no arrest, what I observed, and I haven't seen many, couple of three, trying to get up to speed, but YouTube videos that were way before the Richard Allen arrest. And there's a Charmaine did describe, some people are in it for that. You mentioned, conspiracy theorists. There's a certain segment of that, and there's also a big segment of sleuthers that when something's unsolved, they like to get as much information as they possibly can, and then this one, there was those grainy pixelated photos, there was some audio, and it's almost like there's more participation, more goings on when you have that significant segment who are trying to solve it. And of course it's total speculation, but people are mentioned, what about this property owner that, is right next to it? There's some person that gave a statement that somebody was able to get their hands on the statement. I think they were in Las Vegas and they were questioned, and
a lot of different things.
But it's, and there's a bunch of buzz, and but everybody's on the same.
You cut out there. Everyone's on the same page. Oh, you're muted. Oh, maybe he had to mute himself for a second. Yeah. I think the majority of people, you're muted, but Travis, you must, maybe he has something going on, but I think the majority of people are here, whether it's viewers or not, they're here because they care. Most people would not be here, but they care. But I think that some YouTubers, it's gone to their head, their egos and stuff. But I think Travis, what were you finishing saying? You said you said I think everyone's on the same. Were you about to say page?
That was pretty much it. That they're people are in it for different things, and in the final analysis, the Supreme Court has interpreted the Constitution to say that the Sixth Amendment includes the right to a public trial and a right to public pretrial proceedings. So you have to balance that against state statutes that provide for access to documents, and the judge's job is to balance what the Supreme Court says, what the state legislature says, and follow, the law, and without regard to how it may upset people or what have you. The judges in Florida, their job's easy. Everything's accessible. Other states, they need to balance things, and it's there are cases where attorneys will put stuff that just absolutely doesn't belong. But where I practice, it's exceedingly rare, because we know that the other side can do things to correct that and point it out to the judge. And you're going to get a scolding putting this stuff in that's salacious, that has no bearing on anything. But a lawyer can't, in order to do their job, they can't be second guessing themselves about, oh my gosh, should I put this in? Or, oh my gosh, should I put that in? And, if it's the gag order didn't cover motions, but if they felt, the way the judge has been ruling on stuff, I better submit this under seal and let the judge decide rather than just putting it out in the public. But I got to tell you, if a judge is not following the law and is just saying, I'm sealing these 100 and something documents and I'm not letting these out, and they don't become public until someone files a motion, and then lo and behold, oh my gosh, there's 100+ motions that we never knew about. The gag order didn't cover it. I'm just going to file it, but
Yeah.
it doesn't happen because the judge, if they feel a gag order is appropriate, they enter it. And then most discovery statutes, like in Texas, it's already covered that we're not allowed to turn those materials over to anybody. You can't release them to the public. And you'd be in big trouble for that. But I will tell you, I guarantee you some of those discovery materials have been sent to experts, if they have experts, because you have a constitutional right for your experts to view the discovery.
Right.
But you send them a copy of the order and you say, okay, look, I'm sure you're aware, but in Texas, you're not allowed to share this with anyone, and please acknowledge you understand. And then that covers us. And we're very careful to make sure we're covered on that.
Right.
But I can see why people are upset about certain things. There's highly extraordinary circumstances and very unusual. On the good side, I think things will get back on track, especially if the Indiana Supreme Court gives further guidance to the judge and the clerk, what's proper, not proper. So I'm optimistic about that. We got a firm trial date that I think will end up sticking. And then the other thing is these motions to suppress and the Frank's motion, that stuff's going to get resolved soon. But I've got to take off. But if anyone has any last minute questions, I'd be happy to answer them real quickly. And, hope I didn't upset anybody about delivering the message. But I try and give a very fair and balanced state of the law. Prosecution, defense, and that's why I spend so much time giving the background on why these things are the way. Constitutional right to a public hearing, public trial, and pre-trial.
Yeah. I mean, I don't really have much more to say, but I want to say one thing, just to ask you, Travis. Have you noticed? Or sorry,
No,
I'm
go
not
ahead.
sure if you're. Oh no, what I was going to ask you, have you noticed yourself when you watch news, that now you'll see like News Nation and Court TV. They're bringing on tons of YouTubers, tons of true crime YouTubers. Like they're using them now. That's almost become the new, like meaning. I like the fact. I mean that, like I said, that there's a variety. It's not just based on the news, in the sense that you have true crime sleuths that really deep dive and do good and stuff like that.
Absolutely, I noticed that, and that in freelance journalists are doing more and more and more from their iPhones. Hell, I mean, there's journalists in Israel that are setting up an iPhone with a tripod and broadcasting via satellite. And so that's why, I was a little disturbed by the comment in the emails, which one evening, we'll get to and we'll go through. But that comment about, local content creators are not journalists. The privilege doesn't apply. I'm going to issue an order, and if they don't turn this stuff in, I'm going to them. And I'm like, she's going to be locking up. I don't agree with her on that. I'm a big First Amendment person and litigated a lot of First Amendment issues, but that was one of the indications, like her emotions were getting the best of her, and that's just an opinion on that one specific thing. But it's
I think it was
there's a reason why the media has to be able to evaluate what judges are doing, what prosecutors are doing, what sheriffs are doing, what defense attorneys are doing. The media needs to be able. Those are elected officials that have immense power, especially the prosecutor and the sheriff or chief of police. They have immense power, and the only thing that can counterbalance that is either a specific case where attorneys can do something, or the media, journalists, and whether that now includes certain YouTube creators, which I think it does.
I love boots on the ground.
Newspaper. She keeps referring in her motions on the cameras in the courtroom. I've received requests from legitimate journalists or legitimate news sources. It's legitimate. Evidently, if
everybody else is not.
Yeah, you don't have a cable channel, court TV, or a newspaper. You're not legitimate, and I guess she doesn't consider murder sheets a legitimate news source, or I guess maybe there was some joking that I didn't quite understand at the time about wearing a badge that said media or not. Maybe in one of her orders, she talked about media badges have to be official, and you have to, I don't know. Anyway.
I don't know. Anyways, you know what? It's okay. It's all good. Let's, Charmaine, unless you have another question for Travis before we get going. It's been a 4.5 hour live. I wasn't intending it to be a 4.5 hour live, but Travis, thank you. Did you have, Charmaine, any other question for Travis before we head out?
No questions. Just thank you so much again for another very insightful conversation.
What, Travis, just to ask you, so what's your plans? What your plans tonight? Are you for trick or treats? Are you just staying at home, doing trick or treat, relaxing, chilling?
So we're, up in the mountain, up in Vail, and the Vail's a community. It's very, tourist and visitor oriented. About 25% live here year round versus what the capacity of the town is. But so here we'll probably get maybe 50 or 75, and like I was saying last night, may have been off the air when I said it. So generally, while the sun's still up, the little ones come by, 3, 4, or 5, and then as it gets darker, grade schoolers, older grade schoolers, and then it gets close to around 8, and it's high schoolers, and
Yeah.
we tend to turn all the lights off and blow out the pumpkins and around 8 Mountain Time, and shut it down. And we'll probably have 50, 75 kids, but we like it. Those costumes, those little ones put together are really impressive. So and then just relax, drinking wine. I'll probably have a bourbon or two and relax.
Throw a few back. Yeah. Anyways, Adam just sent a message saying, F October, I don't think I can, or I don't know if I can wait another year. But anyways, can I just say it's kind of crazy because back in the day when we would trick or treat, you went till like 11 o'clock at night and you usually had 2 bags full. But as time has gone on, honestly, now it's like you just said, like 8 o'clock, we kind of start turning the lights off. And I'm just like, that was never in my day, but yeah, I always found that nowadays it was like so soon, like really early. It just, different time, obviously, but now it's like, I remember in White Court, Charmaine, it was about 6:30, everything died off. Seriously, 6:30.
I think I've got 160 days, and once they're go out, there's just not that anyways.
Yeah. Anyways, so you guys, we'll see whoever comes to the live tonight. We'll be doing our Halloween live, play some games and whatever. Anyways, you can come see it tonight for yourself if you're bored or whatever. Same with you, Travis, even if it's just from the chat box or whatever. Just maybe, come to say hello or whatever. And other than that, you have a happy Halloween. Tomorrow, obviously, is November 1st. And thank you for. Oh, I know there's a lot of noise coming from your thing, but thank you so much, Travis, for joining us this morning.
Yeah, I'm gonna take off. Thank you for having me, and
take care.
You you always have really good questions. Sorry if I take a while
really
to answer them. I want everybody to understand the context of them, and not trying to tell people how they should feel or think in reaction to what the judge did today, for example, or the motion. People are entitled. I'm just trying to give a little more background, as neutral as possible, that people can make the most informed decision that they want. And that's it. So thanks for having me again.
Thanks, Travis.
Travis, you take happy Halloween.
If I see you tonight, I see you, but
yeah. Well, like I said, anyways, you have a great evening, with the wifey there. Have a few drinks back and take care. Thanks so much, Travis.
You're welcome. Talk to you soon. You all be safe. Bye.
Talk to you. Hey, Charmaine, I have a question to ask you. Do you have a bunch of snow out there?
No.
Any snow?
Melted. No, it's.
Whoops, what happened? Oh, I'm not sure. Where'd you go? There you are. Okay, you have no snow?
No snow. It all melted. Yesterday I looked outside and it was all gone.
Yeah, I just remember seeing a picture not too long ago. It's totally beautiful and sunny here. Out here in
Grand
Vancouver.
Prairie got a lot of snow. Grand Prairie got a lot of snow, and I'm sure it's coming. But we had some, but it melted. So
I don't miss it. I've spent too much. What were you saying?
I hate the winter here. Oh, it's so bad.
Oh, you know what? The reason why I hate it, like honestly, it's too freaking long. I mean, even though you must be able to tell that the difference, like meaning, for like a lot of times when I was in White Court, you were lucky if you actually had snow before Halloween. Usually it always started like within a week or two after Halloween. But
Yeah.
you can see the climate change like shift and whatever. But I being cold 6-7 months out of the year, no thanks. No,
No,
thank you.
especially this cold, minus 35, minus 45,
Oh
and
yeah,
some weeks on end. You can't even go to work some days. I mean,
I know.
it just goes on and on.
I remember one year it was like, I swear, with wind chill, it was like minus 55. It was crazy cold. I don't know. That was back in obviously 14 or 15 or something like that. But I remember like my ex-husband, he worked for Woodlands County, or he works for Woodlands County still. The work vehicle, it just would not start
No.
at all. And it was, you just literally went outside for like 10 seconds. You were like, yeah, that's not happening.
It's disgusting. There's no reason. There's no reason for it.
But I can just say, because me and my husband were just talking about that, and I'm just like, I do not miss the snow. I like Vancouver. It has 3 seasons at least. We are lucky if we see snow. And when we do, it doesn't matter. Nobody can drive in it because they're so used to rain, if anything.
Yeah.
But I like the greenery, you know what I mean? I do not like looking at that white shit for half the year. No, thank you. And for people that don't get snow, like I said, they're probably going, yeah, I love snow because I don't really get here. Trust me, when you live in it for half of your life, it's like, But anyways, Missy, thank you so much for coming on and sitting with us, and to Travis and you guys. I need to prepare so badly for Halloween tonight because this has knocked me off my schedule. So instead of napping, I got to go back to figuring out Halloween stuff tonight. But anyways, so thank you guys so much. You guys have a great day. Thank you, Travis, for your insight. Thank you, Charmaine, as well, for your questions. I'm going to gloss. And then we will see you guys tonight on the live for Halloween. If you're bored, come join us, okay?
Okay.
Take care.
Bye, everyone.
Take care, everyone. All right. Have a good one. This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all a good night.